Who's supposed to be ready? Trisha Daniels. This is the state of Michigan versus Trisha Marie Daniels, 25-02849, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Straub on behalf of Ms. Trisha Daniels, who's standing to my right.
Okay, today was the day scheduled for a jury trial. This is for animals abandoning cruelty. And then there was a dog licensing matter. And we're ready to call the jury today, correct?
Yes, we are. People are prepared.
Yes, Your Honor.
Okay, any preliminary matters?
Yes.
We have a motion I sent to the court
When?
yesterday.
Oh, you think I sit around all day waiting for last minute motions?
No, I do not believe that.
So I have not seen a motion.
But so I would like to discuss a matter of hearing via Zoom. I also would like to discuss admission of some evidence prior to trial, and I'd like to take the court to take judicial notice of a couple facts.
Okay, the issue of judicial notice, we could do that right before we proceed. What is your other motion? You can make it orally.
Motion, I'd like to have this picture admitted prior to trial. I'd like to use it in my opening statement. So,
okay, so there's no stipulation to the exhibit.
Yeah.
What is the picture of?
this is a picture of the alleged dog that's the dog in this case.
Okay, and what is the objection to the exhibit?
That it wasn't provided timely, Your Honor.
What do you mean?
It was in discovery.
Well, the admission today, the request was not made to me.
That was
now.
That was turned over in discovery.
It's in discovery, and it just hasn't been admitted at the trial. And I'd like to use it in my opening statement.
Is that the only time you intend to use it? Is in your opening statement?
And I mean, I'm gonna introduce it later to have the officer testify to that she actually took it and it is accurately described.
I don't know how I can use it without that happening if they're not going to stipulate.
That's my motion, Your Honor. So
I guess my response is that it's just premature, Your Honor. I mean, ultimately, if he can establish foundation at trial through a witness, appropriate witness, I mean, I guess we can see how that goes.
Yeah, so your motion to admit or to use it without a stipulation, I can't grant that because I don't know whose dog that is. I don't know foundationally, and they have not had an opportunity to, they're objecting at this point. And so if you get it in by laying proper foundation, that's different. The other motion about a witness.
yes, we have a witness who made a call to animal control in this case. Due to his immigration status, he is not available to appear in person. He was in the country at that time, but he's
Not in the country.
He's no longer in the country at this time. He is, I've had consistent communication with him. He's able to appear via Zoom, but due to the nature of his immigration status, we're asking that he be allowed to appear via and give testimony via Zoom.
It's completely up to the defense if they want to waive their appearance in court. It violates their rights if they are not
We do
present.
not at this time, Your Honor.
I think it's my motion act, although it was not timely. I believe the basis for that, there's a sufficient basis for the court to rule in my favor of the motion.
Because the witness is in another country?
Because he's unavailable and we could not be here today due to his immigration status. So I believe there's sufficient court rules for you to allow that. So
We'll take it under advisement. I'll have an opportunity to review it before trial and I'll make a ruling. Obviously, that's not animal control, so.
no, animal control's here. We're ready to go.
Okay, this is an animal related charge. And so is there any other preliminary motions?
Yes, Your Honor. So relative to the remote witness, we would also like to point out that prosecution was fully aware that this witness was unavailable. They actually wrote to the court on January 30th and did not take the proper due diligence to ensure that witness could be here today.
Who wrote to the court in January?
Anna Buckingham on
Oh.
January 30th. She made the court aware through a court judicial assistant as well as court officer, also making defense aware of that fact. Mr. Smith also was aware of this when this trial was adjourned on April 2nd and did not take the proper steps to secure his witnesses' availability. Based on those two factors, Your Honor, I would say that the prosecution has not presented proper substantiation for needing such an exceptional approach today.
And obviously they filed their motion yesterday. Did you get a copy or the ability to respond to their motion?
Yesterday evening, I did, Your Honor.
You filed a
Not
response?
respond, but I read it.
You were, okay, you were able to read it, okay, but no formal response. Okay, I'll take it under advisement and then we'll address it again before we call the jury in. The jury, we can let them know that we need a jury.
The other motion that or not motion, but preliminary matter that I have for this morning, Your Honor, is relative to the expert witness, which also was not presented.
Expert witness.
Expert witness, Your Honor.
Good expert witness.
Expert witness, I do believe.
Good
that
expert witness.
A curriculum vitae was provided to the
When?
court on Friday, excuse me, on Thursday.
Thursday?
On Thursday.
I don't know if that was Thursday.
There's nothing in the file.
Well, our objection is twofold, Your Honor, that it does not meet the timeliness requirement, as well as we were not made aware of the substance of this expert witness's testimony, and therefore did not have time to find our own expert witness or to even interview this witness and vet their testimony.
If I may respond, Your Honor.
You may.
The expert witness actually appeared, her name appeared in the original list of witnesses that we filed back in April.
Well, that's a witness, but that doesn't make it an expert.
Well,
Who was the alleged expert witness?
it's a veterinarian from the animal control. But her name did appear on the original witness list under expert witness. She didn't get the expert witness's resume until just late, but she was identified as an expert witness back in April. So they
Back in April.
Yes, back in April. She was on that list. So that's what I have.
Got it. Okay.
Well, Your Honor, by not distinguishing that witness from the rest of the lay witnesses, we would not have had notice that we needed to vet the witness or to secure our own expert witness.
It was
And that
identified.
does require a pretty substantial process through the public defender's office.
Do we have whatever was filed in
It
April?
was identified
There's
as an
nothing
expert
in this
witness in
file
April.
about any jury instructions
Under
or anything.
the witness list in April, it was identified specifically.
Did you file a witness list with the court in April?
In April, yes. Let me pull it up. Your Honor, I am about 97% sure of that.
Okay, wait, I see a witness is from the defense. Is there a prosecution? I only have a defense witness. April, I don't know. April 2nd, I received one from the defense. Well, I was forwarded one, I should say, to my email from the defense, but nothing was forwarded to me from the prosecution. Is this what you're talking about? April 3rd. And there's nothing in the files. All that stuff has to be printed and placed in files. Can you send me the witness list? Is David on the list? No, but that's why I forwarded it to both of you.
But Your Honor, for efficiency purposes, I do have an email dated April 3rd. I will concede to the expert witness being listed in that witness document.
As an expert witness?
Yes, as
And you all know the nature of the case. This is an animal cruelty, 2 to 3, which by nature would require a veterinarian, you know, or some medical profession.
I mean, it's cruelty
I would
and neglect. So
I would, right, but I would imagine, and I don't know the alleged facts, but I think the alleged facts probably would lend to the idea that they're gonna call the vet. No,
I think ideally, if that vet had had interaction with the dogs, absolutely, Your Honor.
are you saying that in this particular case, the vet did not have interaction?
I'm saying exactly that, Your Honor.
Why is the vet being false?
maybe true. I mean, the vet's gonna lay a foundation that the conditions in which the dog had been left, those establish that it could have affected the dog's health. So that's an element of the crime that's charged, and I believe she's going to be able to testify specifically to condition and how that relates to the dog.
We'll address that in chambers. You stay close. We'll call your case again in just a moment, okay? This is State of Michigan versus Cameron Conley Embry 26-00499. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justice Strauss on behalf of Mr. Cameron Conley and who is standing to my right.
Okay, this was the date and time set for a final trial. This is for 2 counts of domestic violence. Do we have the complaining witnesses here?
Your Honor, at this time, complaining witness is not here. But at this time, Your Honor, I would ask that this matter be adjourned. I have received an email from Detective Booth in this case that charges are filed in relation to witness interference. Detective Booth has been working on that. We haven't, she hasn't sent those over to our office yet, but those are forthcoming. It was identified later that the witness received a few text messages from the defendant. And based off those text messages, she has not appeared in court. So we ask that this matter be set for another final pretrial to see if we can, if those charges are going to be forthcoming or looking to Detective Booth to issue those charges to our office.
Your Honor, we would object to that approach just based on the fact that Attorney Smith did communicate with us on April 7th about these charges that were supposed to be forthcoming. There's nothing that would prevent him from refiling these charges if those charges actually do get filed. I would ask the court to consider dismissing this case today, absent a cooperative complaining witness.
Where's the report? If there was alleged text messages, why didn't I get a report for a bond violation?
Your Honor, the text messages that were sent, I think, a few days before the case had been initiated.
Oh, okay. This has been indeed since March.
So, a few days before they had been initiated,
What are the nature of these alleged text messages?
the text messages allegedly, Your Honor, is something to the effect of defendant says to the witness, why are you talking to the pretrial services people? She says, quit texting me. And then it says something to the nature of, you're full. She says, "Well, you're gonna end up in jail." And then he says back to her, "You're gonna end up dead." So,
That's why, was there allegations of threats?
yes,
Okay.
And that text message came from his phone number. You've been able to identify that.
Well, it's alleged at this point, correct? Because that's the whole point, that there's gonna be charges issued. So, yeah, I would imagine the allegations are that it came from.
and it has his name. She says Cameron in the text message.
And that person does refute in response in that text message, who's Cameron.
But then he goes on later to say something else afterwards. So again, I think it's pretty clear that.
He goes and say something else afterwards about what? About who Cameron is?
About ending up dead. That comes after the Cameron. So.
Okay, so you got a report about text messages?
Well, these text messages were included in the discovery, Your
Okay.
Honor, from the very inception of this case.
Got it, okay. And have you had contact with the alleged victim since the issuing of this case?
He has not been cooperative with our office. I believe Detective Booth, which is here today, if you would like, I could call her.
Please. Is that? Oh, gosh. This is-
Or swear in, Your Honor.
solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Thank you. Okay, you can have a seat. Okay, this is just in reference to whether or not there's an active investigation or potential charges for additional or for witness interference against this defendant.
Okay.
So, thank you. Short notice. I didn't know this was gonna happen today, but we're gonna talk about a case that we previously spoke about relating some witness interference. Detective Booth, are you currently employed?
Yes,
Where are you employed?
with the city of Lansing as a police officer, currently assigned as a detective
And how long have you been a detective there?
since September of 2025.
And were you working in that capacity in January this year?
Yes,
Okay, and there come a time where you were involved in a domestic violence incident, or you investigated domestic violence incident.
yes,
And could you tell us the nature of that incident?
yes. I was assigned a case where a female was assaulted in the city of Lansing. She advised that she was assaulted by two people, one of which was a prior boyfriend.
And do you know the name of that person?
Yes, she provided the name of Cameron Conley Embry.
Do you have you had an opportunity to see a picture of that individual, or would you recognize, or have you come into contact with the individual you just named?
I have seen a photo of him for his Michigan driver's license, but I have not seen him in person.
Is that person present, and the person that you saw on the driver's license, is that person present in court today?
Yes, he's standing to my left wearing a blue shirt and a black jacket.
Your Honor, let the record reflect the witnesses identified as defendant.
Any objection to that? No. It's noted for the purpose.
At some point, is there a time that you did a follow-up investigation regarding some text messages that witness received?
Yes.
Can you describe that for us?
Yes, I was contacted by the victim and the witness and provided two separate screenshots, one of which came from a cell phone number that was described to be Mr. Conley Embry's cell phone number. The other was an unknown phone number with no record.
And do you recall the nature of that text message?
Both messages essentially implied that the witness and the victim should not have contacted the prosecutor regarding this incident without looking at them. I don't want to speak to exactly what it said.
I'll pull them up. If I pulled you up and showed you a copy of those text messages, you can remember
Yes.
without question of recollection. Your Honor,
Yes.
that you view on the screen there, what is that? Well, let me give you an opportunity to just read over it.
This is my police report, my police report transcribing what the text messages said.
Read the text message.
Yes. So the first one was the text message from a number that I was unable to locate ownership records for. I couldn't tell who the phone number belonged to. The first message was from the sender. It states, "You weird for calling that lawyer and pretrial lady. Promise you gon' regret it, watch." The victim responds, "Leave me alone." The sender says, "Say less," and then sends a second message that says, "My people got yo mom address where yo son go to school at and yo sis crib. Watch this and you fucking on a nigga that watch you get beat TF up by some girls and ain't help break it up. and laughed about it. Clown ass, you a goofy. The victim then says, Cameron, stop texting my phone threatening me. You're only going to make things worse for yourself. The sender then says, who is Cam? And I'm done. All action watch with a peace sign emoji. The victim then says, you going to be in prison, LMAO, good luck. The sender then says, and you going to be dead, bum fat bitch. Watch what I tell Dom next.
And based off of that, that text message, what did you do next? What happened next? When can you see when you received or do you recall the time when the witness came into your office to convey this to you?
I received that via an Axon community link, so it was uploaded to me from a link that I sent her.
So since then, have you been able to investigate the crime? This text message exchange? Tell us about your investigation of the text message.
So
I don't need her to go into detail about her investigation. I just need to know, are there going to be additional charges pending?
yes,
Okay, where are we in the process with the pending?
it is in the process of being submitted to Carpel at this time.
What's his name?
Coming to our office. Carpel is the case management system.
In the process of being submitted, what is that?
Yeah. So I completed my report
Okay.
and collected the screenshots as well as the original report. I created a separate case file that was sent to our administrative assistant, who then uploads it to the platform that we utilize to transport cases to the prosecutor's office.
Okay, so it's not been transported yet, is what you're saying?
No, it's pending.
Okay. Okay. Did you have any questions?
Do you? You said your name is Detective Booth?
Yes.
Good morning.
Good morning.
Did you ever make contact with the complaining witness?
Can you provide a name? I'm sorry.
I think her name's Yamala.
Yes.
Okay. And when you made contact with her, did she give you a description of what had happened?
So are you referring to the text message incident or the assault incident?
I'm talking about the assault incident.
Yes.
Okay. Did those statements eventually change? What she told you originally, did that change over time?
Yes.
Okay. So when you received the text messages, how were you confident that those text messages came from my client, Mr. Conley?
So I was confident that the messages from his cell phone number came from him because it would be reasonable to believe that a person who owns a cell phone is the one sending messages.
Okay.
The second message from the number that was unidentified, in reading between the two messages, there was similar lingo, similar abbreviations. So that's how I drew that conclusion.
Okay, so notwithstanding the fact that the complaining witness changed her story to you and recanted her original statement, you were confident that person you had never met.
Objection.
What's your objection?
I don't think there's any foundation to say she can't. You said it changed. You never said it can't. So lack of foundation is my objection.
Well, I think this line of questions has been asked and answered. Any additional questions? You said she was confident that this, you can get into recantation and all that stuff if this case moves, those cases move forward, but that's not what she was called for here today. I literally just wanted to know if there was other charges pending.
Okay.
In fact.
And what is the impediment to those charges being pending for this entire time? Why is it taking so long? Do you know?
So I am, as I stated, a relatively new detective. I was unaware that a completely new case file needed to be drawn for this. So it was added to the original report, which I believe would be my mistake, that it has kind of been in limbo for this amount of time. When it was brought to my attention that it needed to be made into a new case file, I did that immediately.
Okay.
So it could be my fault.
And when did that happen? You created this new case file.
that was created, I believe, on May 6th. It could be the 5th or the 6th.
So sometime last week.
Yes.
Okay, very good. Any other questions? Thank you, Detective. Your motion to adjourn this matter is granted.
Your Honor, there's a co-defendant in this case. We're asking that matter also be, I mean, we can address it right now or later, but Glover,
Chelsea Glover is the co-defendant.
yes.
State of Michigan versus Chelsea Glover, 26-00500. You're Chelsea Glover?
Yes.
Your office is representing both defendants?
Yes, and so Joseph is her attorney.
Appearance, please.
Assistant Public Defender Joseph Hardy, Ms. Glover. Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Okay, so this matter was scheduled today for final pretrial, and based on testimony and other information brought before the court today, there is allegations of witness tampering, at least as it relates to Cameron Conley Embry, and some messages that allegedly went out to the protected party, and as a result, the protected party has failed to appear today. The people have made a motion to adjourn this matter to allow the detective to make meaningful contact with the protected party, and the defense for Mr. Embry has requested the case be dismissed without prejudice. And so now you're brought up to speed. There's now a request, because I have granted, since getting the information, the request to reset this case because there are pending witness interference charges, which likely would explain why Ms. Yamale, is her name allegedly? Okay, why she would not be here today. Versus dismissing this so that it could all be reissued potentially with a new witness interference case that's already in the pending process. And so I was then notified that this is a co-defendant case. So that would involve your client's case as well. Did you want to respond?
Yes, Your Honor. These allegations, I would not object to an adjournment, just I would like to be able to view these texts and have a chance to be able to respond to them.
You've not seen the text?
I don't
Because
believe that.
your co-counsel has seen them, and you all work in the same office.
I'm not sure that they're included in her case.
Okay.
If they're alleged to have come from him.
Yes, so,
Okay, so
Sorry,
your co-counsel has the text messages. So absolutely, you have every right to review them. Who knows where they alleged, one of them, I believe, was alleged to have come from a number associated with Mr. Embry. The other alleged to have come from an unknown individual. I'm not sure why they would not have put this information in the co-defendant file. They don't know who the unknown number is.
I believe it was from like a text app, so.
Got it, okay.
We're still doing some investigation.
Okay, so Mr. Hardy should at least have that information, especially as it impacts his client's ability to move forward today. Your objection is noted on the record, obviously overruled, because I'm resetting it for the interest of judicial economy, and we don't have the victim here because the co-defendant is alleged to have tampered with the witness. So both of these matters will be reset. May 26th at 8. May 26th, 8 AM. Let's see. Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
Thank you. We'll get you new notices to appear. This is State of Michigan versus Maurice Gary, 26-00002. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Joseph Hardy appearing. Now standing to my right.
This is 2 counts of assault and battery scheduled for a final pre-trial today, or was it scheduled for jury trial? The witness here?
The witnesses are been placed on standby. We do have our officers here, so we are prepared to move forward.
Because we already had a final pre-trial, so they must have appeared. Okay, and so obviously this was not the priority case because we're running a trial on a 2025 case. This is 2026. This matter has to be reset. July 7th at 8. July 7th at 8 AM. You have any questions for the court today, sir? Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. State of Michigan versus Isaiah Hollins, 26-00421. Appearance, please.
Thank
Is
you,
he
Your
in
Honor.
custody, actually?
Who's that, Joseph?
Hmm?
Who's that? Thank you, Your Honor.
Nothing's happening on my docket, that's why. He might be in custody. I'll have to call that in just a moment. State of Michigan, if he was in custody, he's not in custody on this go, right?
No, we need to be bonded out Friday, Your Honor.
Oh, okay. You believe he bonded out on Friday?
Yeah.
Have you had contact with him?
Your Honor, but I did get receive notification from the prosecution. I believe there were allegations that he was at the Caddis station. So just want to make the court aware of that. When I checked the jail roster, he did not appear to be down. So.
Security guard guy called me yesterday, the day before, and told me that he was there at the location.
Is it gonna be a report for a bond violation coming from that? Was the police
Yeah.
called?
They did not call police. No.
Okay, God bless you, whoever that was. Okay, I'm gonna issue a bench warrant bond forfeiture. You're all set on that one. State of Michigan versus Christopher Lewandowski, 6-00305. Appearances, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appear on behalf of the people.
Hey, good morning, Your Honor. Joshua Nushin here. We have a Christopher Lewandowski who stands to my right.
Thank you, Mr. Lewandowski is scheduled for final pretrial today. This is for 2 counts of stalking.
That's correct.
And then there was a bond violation hearing. Did we have the witnesses here?
Yes, Your Honor, we do.
Okay.
Your Honor, there is a resolution at this point in time. The prosecutor and I can place that on the record. It should take care of
You have a
the
plea sheet.
open issues. I started filling it out for the prosecutor.
And you have an advisory right.
Yes, we have that.
Okay, you can send it all at one time.
Okay.
No. Ross did not mention that.
Your Honor, may I approach you?
Thank you. Okay, it says that there will be a no contest plea to amended count 1 of aggravated stalking, dismiss count 2, sentence agreement to no upfront jail, sentence agreement to initial term of probation being
Caps.
capped at 12 months, dismiss bond violation, can't be a part of the plea deal. That's a contempt of court order issue. Allow defendant to return home, no objection to GPS tether being removed.
That, Your Honor, I'm standing in for Attorney Ross Martinez for this case. So I believe that accurately reflects the agreement that we entered into with the defense counsel. I think the dismissal of the bond violation is a recommendation.
Okay, and then the alleged victim, I'm trying to understand the return home thing.
So part of the bond amendments that we had in March, the defendant was allowed to return home during business hours for work purposes.
Oh, wait a minute, this is the neighbor issue?
Correct.
Okay, I remember
And
now.
so-
Martinez, yeah.
Yeah, and so
Got it.
part of the plea or the global resolution would allow Mr. Levinowski to return home today. Ross has no objection to the removal of the tether.
This is, was this the one, the allegation about some water from a hose?
Correct.
Oh, okay, well, dismiss that.
So we're trying to globally resolve it.
Got it, sounds good. That's how you want to proceed, sir?
Yes, ma'am.
Is there a police report? What is the reason for the no contest plea?
Civil liability, Your Honor. I can give you a copy of the incident report if you'd like.
If you could highlight the relevant portions while I go over his rights. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can put your hand down. This is an advice of rights and plea information sheet. Is that your signature?
It is.
You understand these rights?
Yes.
And are you willing to waive these rights today in order to enter the plea agreement as stated on the record here?
Yes.
Okay, so you understand that you have the right to be presumed innocent until proven guilty. You can maintain your presumption of innocence, required that the prosecutor take this to jury trial and prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial. They can't use that against you. You have the right to waive your silence and take the stand and give testimony if you like. You have the right to see, hear, and question in court any witness that's called to testify against you, and the right to have witnesses subpoenaed to testify on your behalf. You understand each of those rights? Anyone promising you anything not stated here on the record to get you to waive those rights? Has there been any threats or inducements to get you to give up those rights?
No.
Are you currently on probation or on parole?
No.
You understand that a no contest plea I'm sorry? I didn't finish my question yet.
Yeah, yes, it is.
So how are you saying yes? Eager. Okay, do you understand that a no contest plea could result in a conviction that you may need to report on a future job application? So my understanding is that you're self-employed now, correct? Okay. So you may have to report a conviction if convicted by way of no contest plea on a future job application. You understand that? It also could have impact on where you can travel or get immigration status.
There's a victim here present for this case. May I go grab that?
Please. You can approach counsel with the.
Thank you, Your Honor.
Certain paragraphs for reference.
that there's a script. It's not that big. What happened?
Police report, I gave you sufficient. Did you review it?
Yeah, what's sufficient to me? We need to go find Mr. Smith because we don't take that one. The building's not big enough for them to not have been here. So, that over there. Okay. Okay.
Apologies.
Okay, thank you. Mr. Lewandowski, as to the amended count one of aggravated stalking, how do you plead? I have a police report here from the Lansing Police Department, incident report 25-01371-1. The indications that on or about June 7th, 2025, or between that time frame, officers made contact with a person, individual named Melissa Andrus. Andrus advised that her and the defendant, her and another individual named Wright, last name Wright, have been victims of ongoing harassment from the defendant, Mr. Lewandowski. Andrus advised last year they came to their porch with ski masks on and stuck a threatening note in their door. Further, Andrew said that the Lewandowskis continued to mow into Wright and Andrew's lawn, stalking it. Andrews advised she had several clips of video and photo from these incidents, which she would send to me. There's a notation of Rebecca sent me a photograph of the damage done to their lawn. I uploaded the photo to evidence.com under this report number. Andreas also sent me several photos and videos related to her side of the story, which I also uploaded into evidence.com under this report number. Secondary call for service indicated that on or about June 11th, 2025, at approximately 1945 hours, that officer was dispatched to 6145 Nora Burn Way, City of Lansing, Ingham County, State of Michigan, for a neighbor complaint. This time, Andrews was calling to report Rebecca had taken her metal fence pieces out of her yard and thrown them. Further, Rebecca removed 2 fence panels from Andrews's wooden fence and threw those in the yard as well. Any additional factual basis?
People are satisfied.
The court is also satisfied with the factual basis. I find the reason for the no contest plea to be appropriate. So an entry of guilt or conviction will be sustained by way of no contest plea, that is. This matter will be scheduled for sentencing on July 7th, 2026 at 9 o'clock in the morning. So you're gonna go and check in with our probation department so they can prepare the court with a pre-sentence interview investigation report, okay? We do have a victim here today, and I will allow her to render any impact statement today if she'd like, so that she does not need to return on the 7th if she doesn't want to.
They come back on the 7th?
You absolutely can. No, you absolutely can, but I didn't know if you didn't want to, so that's fine. July 7th, 9 a.m. For sentencing. Any additional matters for her?
I believe, Your Honor, we agreed to maybe allow him to return home.
It's part of the agreement.
I still have concerns about there being, no threatening or harassing behavior going forward. So although we probably can't put a 2,000-foot no contact order in place, I'd like to still continue to ensure that there's no threatening or harassing behavior that's going to be going on between now and the end of any term of probation.
And Your Honor, we understand bond conditions are still in place right now until sentencing, with no threatening, assaultive, intimidating, harassing behavior. We're just asking that you allow him to return home and remove the tether at this point.
For the negotiations of the parties, I'm going to allow him to go home at this point, and I'm going to allow the GPS tether to be removed. Again, as your attorney has indicated, you are still under bond conditions. He's not been sentenced to probation yet. I don't have to sentence you to probation. I can sentence you to jail. And something that would make me more inclined to do that would be doing something stupid, like having hostile, aggressive communication with your neighbor now that you're home. It's ridiculous. Be neighborly, and we won't be here. So nonetheless, bond conditions otherwise will continue, as well as the no contact order. You need to go back down to the county to have them remove your tether though. So we will notify them.
Provide an order. Do we need to take an order with them? or-
We just emailed them. Yeah. Okay, and then he's gonna go downstairs first to check in with probation before he leaves here. The bond violation is dismissed. Any additional matters for the record?
No, Your Honor.
Nothing from the people, Your Honor.
Thank you.
May I approach for the
Yes, please.
couple pieces? State of Michigan versus Dalen Morton, 26-00528, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Joseph Hardy, after Ms. Martin, just making their way to the podium.
Is here. This was scheduled for final trial for assault and battery. Is the complaining witness here?
Complaining witness not here. We've attempted to reach out to complaining witness. I had contacted him once, but since then he hasn't returned my call. The state cannot sufficiently move forward without the complaining witness, so this time we move to dismiss this case.
Motion to dismiss is granted without prejudice. The people do have the right to reissue it against you. You understand that?
Yes.
We'll get you a copy of dismissal in just a moment. State of Michigan versus Jason Saller, 25-00533, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Under Justice Ross, on behalf of Mr. Jason Tyler, who is standing to my right.
Had a jury trial today for malicious destruction of property. We are running another matter today, so we can't proceed. Is there a resolution now at this time?
Yes, Your Honor.
What is the resolution?
The offer is to amend count one to malicious destruction of property under 200. And there is,
No, we're not asking for restitution.
That's correct, counsel.
Yes, Your Honor.
You want to accept that, sir?
yes,
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Counsel, that's it, right? Okay, and then Mr. Sauer, you understand your right to the presumption of innocence?
Yes,
You have the right to maintain your innocence and proceed to a jury trial and require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You understand that? You have the right to remain silent at any trial that can't be used to prove or imply that you're guilty. You have the right to question any witness that is called to testify against you, and the right to subpoena witnesses to testify on your behalf. You understand those rights?
that's it.
You're willing to give those up today to plead guilty to the amended charge? Anyone directing you to do that?
No,
Any promises being extended to you to get you to plead guilty to the malicious destruction of property less than 200?
no,
Are you currently on probation or on parole?
I'm on probation, Clinton County.
Until when?
I think it's another year. Yeah. So I got like 2 years.
For another year?
Yeah. But I've been doing, I was in TRICAT for 5 months, so it all adds, and I was in jail 10 months before that.
You understand that by pleading guilty to result in a conviction, that you may need to report for your probation status.
Okay.
You understand that?
Yes, I do.
It also could be a conviction that may have impact on travel or immigration status. You understand that?
Yes, I do.
It also may need to be reported on a job application or be reported to your current employer. You understand that?
Yes, I do.
Lastly, are you looking to plead guilty because you believe that you are guilty?
Yes, I do.
As to malicious destruction of property less than 200, how do you plead?
Guilty.
Factual basis.
Mr. South. On January 12th of 2025, were you located at Northeast Street in Lansing, Michigan, 48906?
Yes, I was.
And at that location, is there a place of business called House of Faith?
Yes, I was.
Okay, and this place is located in Eaton County. And at that location, did you maliciously destroy or injure a mailbox?
Yes,
And was that mailbox located on a front grassy area in front of House of Faith?
that's correct.
I do think that satisfies me.
People satisfied.
If we're satisfied with the factual basis, I'll accept your plea or find your plea to be voluntarily and intelligently made. He's on probation until when?
I think he said for another year.
Sentencing date is July 7th at 9 a.m.
Would your honor entertain a motion for immediate sentencing?
I will not.
Okay. Like to appreciate that.
Yes. Or get an update as to his probation status and requirements from Clinton County, so that we can see what needs to be done, if anything, on this end. So you'll report and check in with our probation department before you leave here today, okay?
Okay.
Any additional matters for the record?
nothing on the paper, Your Honor.
Okay, thank you, Your Honor.
Thank you. State of Michigan versus Rhonda Wade, 25-03773. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
This is Public Defender Justice Rob on behalf of Ms. Rhonda Wade, who is standing to my right.
Ms. Wade was scheduled today for jury trial. Do we have witness here?
Yes, we are prepared.
Is there a resolution?
No, it's not, no.
Okay, so this is continuing to trial?
Yes,
Okay. This has to be reset because we're running another trial. Is May 26 at 8 for this one? May 26 at 8. It's probably the priority.
Yeah.
Yeah, this is the priority because it's a 25 case. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing further, thank you.
You're all set, thank you. State of Michigan versus Dylan Ayers, 26-00526. Appearances or no?
Thank you, Your Honor. May it please the court. I didn't know you asked for appearance. Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justice Rob on behalf of Mr. Ayers, who is here remotely.
Okay, this matter was a domestic violence pretrial. Was there an offer at this time?
There's no offer at this time, Your Honor.
Final pretrial?
Yes.
June 23rd at 8 a.m. Final pretrial. And July 21st at 8 a.m. for jury trial. Okay, Mr. Ayers, your matter is scheduled for jury trial in person at the court, June 23rd at 8 a.m., okay?
Okay.
I'm sorry? That was the final pretrial. I'm sorry, that's final pretrial. I don't know what I said. That's scheduled for final pretrial on that date, okay, sir?
Okay.
Okay, your jury trial is gonna be scheduled July 21st at 8 a.m.
All right. So June 23rd and July 21st.
That is correct.
Okay.
Do you have any questions at this time?
No, Your Honor.
Okay, any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the thank you.
Okay, we'll see you June 23rd. Bond will continue.
Okay.
Are you waiting for someone to take you downstairs? What happened to David? They took the other person and forgot to take him. He just went downstairs. He's right there. David, did you forget to take him downstairs?
No, I'm still working on this.
Oh, okay, got it. Okay, State of Michigan versus Trina Jackson, 13-03695. Appearance.
Thank you, and Your Honor, may it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Justice Rob on behalf of Ms. Sheena Jackson, who is standing to my right. This is.
We're here for a 2013 retail fund in 2026. How are we proceeding?
Your Honor, we even asked for a final pretrial.
The offer is to plead to a trespass with restitution for $96.97.
$96 and what?
97 cents.
Target?
Yes. And because it's a target case, I just asked that the matter be set for trial.
Because the Asian case, I'm gonna have to hold a final pretrial. Final pretrial, June 23rd at 8 a.m. And then jury trial, July 21st at 8 a.m. Final pretrial, June 23rd at 8 a.m. Jury trial, July 21st at 8 a.m. We'll get your notice. Bond will continue. Do you have any questions at this time? No. Okay, you have until your final pretrial to decide if you want to accept the offer, okay? Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing from defense, thank you.
We'll get your notice in just a moment. Is Brandon to carry on? Brandon's in custody, correct? For dog cases. Who wants to go speak to him? I'm not bringing him up for that. Nathaniel Schenkel. Is he here?
He informed me that he'd be logging our page soon.
Well, we don't see Nathaniel Schenkel on Zoom. Well, it should bench warrant.
Your Honor, just for the record, Nathaniel Shankle, the complaining witness, his grandmother, she is present today in that court, so I would ask that her future appearance be waived.
She's out. Oh, I don't need you to bring her in. She's just here.
She's in the jury room.
Oh, okay. He was supposed to also provide the court with a valid address within 24 hours of his release. Did he do that? No. I was sure bench warrant. Okay. Nathan House, what are we doing with that? Not a review. See a file. Oh, that's for information. Oh, okay, so I can take that off, yeah. Is Henry Griffin here? No, Henry, you want to say it's fine? Okay. Johnson, maybe? Let's see. Schultz, present. Kip Schultz, no.
No.
Kip Schultz?
I know.
Thank you. Tiffany Terry here? No. Not sure if they did. Oh, yeah. Today. Sean Benavides. Oh.
Your Honor, that was, Sean said at 10, not quite 10 yet.
Oh, we're moving quickly. Let me cross that bench warrant out. Okay, so we're all caught up. We just got 10 o'clock and Brandon is downstairs. Who's representing Brandon? Do we know? To carry on Brandon?
Mr. Ferguson go downstairs and talk to.
Oh, Mr. Ferguson's gonna.
Yeah.
Okay, good. I mean, it's doggish situation.
My hope is that because he's been in custody for a while, he doesn't have the dog anymore.
Who's representing Mr. Cruden?
It's not me, Your Honor. I can check.
Mr. Cruden is ready.
We're ready to go. I'm putting your on.
State of Michigan versus Ivan Cruden, 26-0105, appearance, please.
Public defender Joseph Hardy, Mr. Proven.
Okay, Mr. Cruden has a domestic violence. We don't have a prosecutor though. Where's the prosecutor?
Yeah, talk to the defense attorney.
Can I have your appearance on Ivan Pruden, please?
Your Honor, may I please support Assistant Prosecutor Attorney Dan Smith here on behalf of the people?
Okay, this is a domestic violence pretrial. Has there an offer been extended?
Ivan Pruden. I don't believe an offer has been extended to my knowledge, Your Honor.
You want a final pretrial?
Yeah, final pretrial will be our request.
23rd at 8 AM for final pretrial, jury trial, July 21st.
Okay, Mr. Pruden, you have a jury trial, I'm sorry, a final pretrial. That's gonna be scheduled on June 23rd, 8 AM. You must appear in person. And then your jury trial will be July 21st, okay? You're muted.
Yes, ma'am.
Do you have any questions for the court at this time?
What were those times again, ma'am?
Both 8 o'clock in the morning. The first date is June 23rd. The next date is July 21st.
Thank you,
Any other
ma'am.
questions? Okay, you're all set. Thank you.
What is this?
I don't know who they're putting on.
Yeah.
Mr. Shangle, can you go ahead and join that breakout room?
Oh, I'm retarded.
All right, I'm here. Thank you.
Mr. Shangle, you cannot vape in this courtroom, so you have to put that away or put it aside.
I didn't know I was in the courtroom, sorry.
Without you, there I am.
we find out what's going on with the query on Brandon?
Want me to grab Attorney Smith?
I'll do that. Just walked out. Let's see what we got.
Sure, Your Honor. It is my understanding, though, that he was considering dismissing those cases. I'll let him speak to that.
Okay, what are we doing with the query on Brandon? Do we know? Counsel? The dog cases?
Yeah.
Oh, yeah, we just.
Okay, both?
Yes.
Dog and Russian dog. also.
Yes. Formally move to dismiss. Okay.
State of Michigan versus Sean Benavides, 26-01-04, Pants case.
Your Honor, may I please support Assistant Prosecutor Attorney Dan Smith, here on behalf of the people.
Good morning, Your Honor. Attorney Amberly, P84377, standing in for the Attorney of Record on behalf of Mr. Sean and of Benavides Jr., who appears via Zoom. Mr. Benavides, can you please unmute and state your full name for the record, please?
Hi, my name is Sean Benavides Jr.
Okay, this is a dog at large matter was scheduled for pre-trial. Let's see. Has this matter been resolved?
I don't believe so. I haven't had opportunity to speak with counsel about the case. I do know that it's alleged that Mr. Benavides' dog had hopped the fence and he killed his dog, allegedly killed a couple of chickens of his neighbors. So there will be a restitution amount for those chickens. So ask this matter be rescheduled to allow us to speak about any resolution.
No.
It'd be May 26th at 10:30.
We're gonna reset this to May 26th at 10:30. You need to speak to counsel in private time.
Yes, Your Honor, I'll let the attorney of record know that.
Like I said, May 26th, we have another trial date, so we won't have time to, we'll be running another trial, I believe, that day as well.
Yes, Your Honor.
Any other matters for the record today?
Other from the people, Your Honor.
No, Your Honor.
Okay, you're all set. Thank you.
Thank you, Your Honor.
Hey, thank you, Your Honor.
Thank you. Michigan versus Jim Macon, 26-00843, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Smith here on behalf of the people. This is about the defendant Joseph Hardy, behalf of Mr. Macon.
Okay, Mr. Macon is present via Zoom. This is an illicit destruction of property, pre-trial, that is. How are we proceeding?
At this point, we would like to request a final pretrial.
Is there an offer at this time?
Your Honor, there's no offer made at this time.
Final pre-trial June 23rd at 8 a.m. Jury trial July 23rd. The final pre-trial, Mr. Macon, will be in person at the court June 23rd, 8 o'clock in the morning. And then your jury trial is going to be scheduled July 21st, also at 8 o'clock in person at the court. Do you have any questions today?
No, Your Honor.
Okay, any additional matters for the record? You're all set, sir. Thank you.
Thank you.
You're welcome. State of Michigan versus Deontay Pugh, 24-0074 or 751, that is. Counsel appearance.
Thank you, Your Honor. May it please the court, Prosecutor Attorney Dan Smith here on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Joseph Hardy, appearing on behalf of Mr. Pugh, who's standing to my right.
Okay, Mr. Pugh has a pretrial today scheduled for domestic violence. Was there an offer at this time?
To my knowledge, no, Your Honor.
No, an offer hasn't been made at this time, Your Honor. We're asked that this matter be set for a final pretrial, and it's time to consult counsel within the offer.
Trial June 23rd at 8 a.m. Jury trial July 21st at 8 a.m. You have to be a person for both those dates, okay? Do you have any question at this time? Okay, any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
Thank you, you're all set. State of Michigan versus Sabrina Vieri, 26-01119, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appearing on behalf of the people.
Assistant Public Defender Joseph Hardy, appearing on behalf of Mr. Bieri, who is appearing via Zoom.
Okay, Mrs. Bieri has a pretrial that's scheduled today for domestic violence. Has an offer been extended at this point?
Not to my knowledge, Your Honor.
Final pretrials?
Oh, sorry, an offer has been extended. You're offering to plead under 769.4A. We would like to request a final pretrial at this time.
Pretrial June 30th at 8 a.m. Jury trial August 4th at 8 a.m.
That offer includes the alcohol assessment, treatment, and recommendations.
What's the date on the jury trial?
Final pretrial is, you said June 23rd? June 30th. June 30th. And jury trial August 4th. August 4th. Okay, Ms. Bieri, your final pretrial will be in person at the court June 30th, 8 o'clock in the morning. You have a jury trial that's currently scheduled for August 4th, 8 a.m. in person at the court, okay?
Yes, Your Honor.
Do you have any questions at this time?
No, Your Honor.
Additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set.
Thank you.
You're welcome. State of Michigan versus Ashley Hart, 25-01646, appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the plaintiff.
Assistant Public Defender Justice Strada on behalf of Ms. Hart, who is appearing remotely.
Okay, this is an assault and battery pre-trial. Was there an offer?
Arms. There was we just had an agreement to no upfront jail.
There's no offer, Your Honor.
No offer, final pre-trial?
Yes, please.
June 30th at 8 a.m. Jury trial, August 4th at 8 a.m.
Okay, your matter, Ms. Hart, will be scheduled for final pre-trial, June 30th, 8 a.m. in person at the court. Jury trial will be scheduled for August 4th. Do you have any questions at this time?
I'm kinda, so are we're taking it to trial, right?
Correct.
Okay,
Also,
Go ahead.
We would also like to ask the court to consider releasing Ms. Hart with a tether.
Tried that. She didn't come to court. I don't babysit anymore. Okay. You get a bond and you don't come to court twice, then don't ask me for a bond anymore. Any other
okay,
questions?
What is her current bond?
Remand, because she failed to come to court twice.
Okay, so she is currently collecting credit. Perfect. Thank
She's
you.
actually requesting time.
okay, so I'm remanded.
That is correct, because you don't come to court.
Your Honor, even if I'm on a GPS tether,
No, you don't, you're not getting out, because we let you out. And you didn't come to court, and you think it's my job to track you down to handle your affairs. And I'm not doing that. I don't have the patience to track down adults for their court dates anymore. So if you are granted a personal recognizance bond and you squander it not once, but twice, do not ask for another bond.
okay, Your Honor, yeah, I was homeless at the time, so that's another reason.
That you're being homeless has nothing to do with you coming to court.
I understand, Your Honor. Is there any way at all you can give me a bond at least?
I definitely just readdressed this multiple times. Do we need a competency evaluation?
No, I think what she's asking for, Your Honor, is maybe a 10% for a cash surety bond, but I think Ms. Hart, what the judge is saying is no.
Is that going to change anything? She doesn't have the ability to post a bond, I don't believe.
No, I don't think she does.
Yeah, so giving you a bond, I can give you a bond if that make you feel better. Your bond, the last personal recognizance bond that you squandered was 600 personal recognizance. So we'll go ahead and set the bond at $600 cash only with GPS tether.
Okay.
Okay. Additional matters for the record?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
You're all set.
Thank you.
You're welcome. Okay, State of Michigan versus Cameron Johnson. Is he gonna be put on? Or is he downstairs?
I think he's the same.
He's downstairs?
Yeah.
Yeah, he's downstairs. I'll go grab
Did
him.
someone speak to him
I did speak with him last week, Your Honor.
last week?
Yes,
What is his schedule for this week?
he is scheduled for pre-trials this week, and I do believe that there is an assault and battery or a domestic violence charge, and then 2 malicious destruction of property, plus a contempt hearing.
What are we doing? Because I'm not bringing them up right now just for us to reset it. Because we're about to run a trial. So what are we doing with these?
Your Honor, setting for final pre-trial. which might also be convenient relative to the contempt hearings. All witnesses come the same day. I'm not sure if they're here today.
Did you get a rain on the contempt? Yes. These are gonna be set for final pretrial, all of them. Let's see. It's a animal abandonment.
No, that one is not mine. That is Daniel Sturdivant's case.
And one is already set. Yeah, one is set for final pretrial at 10:30 for some reason. So is Mr. Sturdivant here?
I think, Your Honor, I believe he's down in lockup.
Probably talking to him. Okay, we'll find out what's going on when he comes back. State of Michigan versus Paula Thornton. This is 25-03648. Appearance, please.
Thank you, Your Honor. May it please the court, this is Prosecuting Attorney Dan Smith, appearing on behalf of the people. Public Defender Joseph Hardy, appearing on behalf of Ms. Thornton, who will stand to my right.
Ms. Thornton has a furnishing false information of pretrial today. I think this might be the first time I've seen this from this county prosecutor, not the city. How are we proceeding?
At this point, we would like to request a second pretrial. At this time, an offer has not been made. We would like to continue into plea negotiations and possibly have a resolution at the next pretrial. Your Honor.
Other people intending to extend an offer on this?
We probably will, yeah. I don't know what that office might be
Okay.
right now, but yeah, this final pretrial will have it settled by.
June 30th at 8 a.m. final pretrial.
We don't need to have a final pretrial for that because furnishing false information with them, we're not calling witnesses. I just set it for another pretrial.
We can do May 26th at 10:30.
May 26th at 10:30. Do you have any questions at this time? No. Okay, we'll get your notice to appear. Any additional matters for the record?
Another from the people, Your Honor.
No, Your Honor.
Okay, I'll set for that one. Thank you. They, drop off the jury thing.
Yeah, it should be, it's subject.
The other one.
Oh.
That's right. That's in the printer.
Oh, okay, got it. No worries. And then, did you forward them the jury instructions? It's the same thing. One motion there. And then council, I need to address motions on the Daniels matter. The jury is here, so we need to move forward. Oh, does she have my list? Or is it on my office? Where here? The list, the jury? Oh, this is yours. She got it. I got it.
She said one thing or two.
Or did we figure out what's going on with Johnson?
Your Honor, yes, I believe he is pleading on one of the counts. And counsel is going to reschedule the malicious destruction of property and the domestic violence cases. There was an offer made on those cases to dismiss both most malicious destruction of property under 7649A. People believe we have sufficient basis to move forward with that charge without the alleged victim. So we
Wait,
would.
which matter is this?
So Mr. Johnson.
No, well, I know it's Mr. Johnson. He has several cases. Which matter are you talking about?
So counsel has that dog case.
Okay, animal abandoning.
Yes. And he's gonna plead that case.
Okay, but that doesn't resolve all of these matters.
Yes, Attorney Stroud has the other 3 cases. On those other 3 matters, the people have made an offer to dismiss the 2 malicious destruction of property cases for a plea to the DV under 7649.
Then he also has multiple bond violations.
Yes.
And what is he doing on yours?
At this time, Your Honor, we would ask to set for final pre-trial.
One of them was set for final pre-trial today.
Which one is that?
24-00912.
That appears to be the domestic violence, is that correct?
Correct.
Okay, well, at this time, we would move to dismiss.
Was a witness subpoenaed?
The witness has not appeared, Your Honor. Again, but my position is that people have sufficient evidence in this case with
Proceed under hearsay rule.
yes, to move forward with that. So we would ask that the matter be set for trial.
Try. So he's gonna plead only under the animal cruelty one. That is 25-00164. The other ones are being set for trial. August 4th at 8 a.m. August 4th at 8 a.m. He could be brought up on the evidence.
Your Honor, August 4th date, is that jury trial for all 3 matters, or is that just for the domestic violence matter?
All of them are gonna be set for that, but obviously we can take the oldest case first. When it's time to run a trial.
Is the court amenable to the malicious destruction of property cases being set for final trial?
Versus a jury trial,
Yes, Your Honor.
for what purpose?
To see if the complaining witness shows up. It is my
Okay.
understanding that the hearsay.
You gotta show up for final trial. I mean, for jury trial too. I don't understand.
Okay, well, we can do it that way, yeah.
You said August 4th.
Yeah.
While he's being brought up, back on the record in the matter of the state of Michigan versus Tristan Daniels, 25-02849. Our counsel, thanks.
Thank you, Your Honor. May I please, of course, Assistant Prosecutor Attorney Jansen, on behalf of the people.
Assistant Public Defender Justice Trial on behalf of Mr. Tristan, who's standing to my right.
So we have two motions. The jury is here. Two motions the court needs to make a ruling on. I believe there's one about expert testimony, in that the people are looking to call a veterinarian, and then have them qualified as an expert. I think that there was sufficient notice provided to your office, because that there was notice in the original, in the April iteration of jury instructions, that that person was identified or intended to be identified as a possible expert witness. Whether or not they'll be qualified as experts, totally different. The other concern as it relates to this is you would know better than the court would regarding the nature of the allegations. And just based off the affidavit of probable cause, the allegations were that I believe there was an animal left in the cold on the porch or something to that effect in the kennel. And so the allegation is that that would cause some harm or cruelty to the animal. I don't think it's unreasonable to think that a vet would be called for animal cruelty. Typically, animal cases is gonna have animal control and the vet. It's typical, so I don't think that's particularly an ambush issue. So I will grant their motion to allow them to call that witness and deny your motion to exclude that as a potential expert witness. We'll deal with qualification once the foundation is properly laid. So if you need to re-raise an objection, that you can do so at that time. As it relates to the motion for a district court to use Zoom to take testimony of the witness. My understanding that this is a witness that allegedly contacted animal control.
Yes. Yes,
And
sir.
why, again, is this witness not in the United States?
Due to his immigration status.
What do you mean due to his immigration status? He just got picked up, or did he have a warrant to which he got picked up? A criminal matter.
From my understanding, Your Honor, and I know he has a Fifth Amendment privilege, but from what I gathered, when he may have been here illegally, when Trump came into office, he self-deported
Okay. So it wasn't that he got a criminal conviction or picked up on a criminal matter and that's why he was deported, because that would change my position. Then I do deem him as being unavailable. Under the court rule exception, I will grant him the permission to appear via virtual access to give testimony because of the ongoing issue. I don't see how he could be available and be in this country at this point without a proper immigration status. Any additional motions that I did not rule on?
There's a particular matter, Your Honor, that I would like to address. I would like the court to take judicial notice of a couple facts. I believe there's sufficient basis for my reading.
Why am I saying judicial notice? Because this is a jury trial. So what am I gonna do with it?
A couple facts that I would like to use in my opening statement.
Okay.
Regarding the care for this particular animal. The American Kennel Club has indicated that this particular pet in this particular case should be exercised several times a day, and that in the winter it should be exercised in the house. The American Kennel Club also states that this clean, fresh water should be available to this dog at all times.
This particular dog
This particular
versus any other dog.
this particular breed of
This
dog.
is like a specialized breed of animal, is what you're saying?
I'm reading it right off.
Your witness, your expert can't testify to that?
I'm not sure if they can or not.
Okay.
But this is
something that you want to state in your opening.
yes, that's it. That
Okay.
the premier organization that handles dogs, but they've made a conclusion that these two things are a fact about this particular breed of dog.
Your Honor, it is my understanding that judicial notice is appropriate where facts are obvious, or where something is so evident, right, that there is no debating it. I would absolutely say that this is a matter for debate. It is not for us to determine today whether or not this material, I have not reviewed it. I really don't know what it says.
I don't either. I'm not familiar and I don't know that I can take judicial notice of whatever. What is it, the American dog?
The American Kennel Club, they're the one that holds the special like dog show every year.
Listen, I can't help you with that. I don't know anything about it. I don't have any pets. So I don't know who holds the special, any of those things. I don't know anything. I don't even know what this particular breed would look like. And so I would imagine if this was a specialized issue, those are the reasons why we have expert witnesses, and so that they can testify if there was a special condition upon which this particular dog needed to be kept. I can't take judicial notice of that. That's not something that's common. Or, you know, something that went through this court system, and that's why I'm taking judicial notice. So for that reason, no, I cannot take judicial notice of that you're gonna have to lay foundation to get that information in.
Okay.
Through one of your witnesses. Any other, you said you had a couple of issues?
No.
Okay, they were all relevant to that? Okay. And then you're also gonna lay foundation as it relates to the picture.
Yes, so you're denying my
Okay.
motion to introduce this during the opening statement.
Okay, and so any other matters for you?
Yes, Your Honor. So I do believe that the last time we came before this court in this case, that it was clarified that the license count had been dismissed. I don't think that it should be on the verdict form today.
The issue.
Yes, we took this matter up with Hannah Buckingham.
Yeah, Nolly, no license was on February.
And then lastly, from defense, we would just simply ask this court to sequester all the witnesses.
Sequestration is granted. Any other matters?
Not from defense.
Let me see. And did you receive the jury instructions? I would need to delete the no license jury instruction. Any other changes that need to be made?
I haven't had an opportunity, Your Honor, to take a look at them.
Okay, if you can do so at the same, I'm going to obviously handle that matter for Mr. Sturtevant's clients. And then. Oh. And then we'll call this case again.
Thank you.
Verdict. The verdict form, proposed verdict sheet. You can let us know if you want changes.
Okay.
Your Honor, may I approach?
Thank you. That's what it is. I need to take it up from there. Back on the record, or on the record, that is in the state of Michigan. Versus Cameron Johnson, 25-00164. Appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith.
Morning, Your Honor. Daniel started appearing for Mr. Johnson, who is here in the courtroom standing to my right.
Tired. 25-00164. Oh, so what's this for? Let me read what I have here. Today was the date that was scheduled for a, was this final pretrial? No, this one was just a pretrial.
Right.
Okay. And then my understanding is that the defendant is going to plead to an amended count of attempted animal cruelty. Is that correct?
Yes, with agreement for no further upfront jail at time of plea and Home Equal Training Act status.
You want to accept that offer, sir?
Yes.
Raise your right hand. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Okay, this is an advice and rights and plea information sheet. Is that your signature?
Yes.
You can put your hand down, sir. You understand that you have the right in this matter to proceed to a jury trial?
Yes.
You are presumed innocent until proven guilty. Do you understand that?
Yes.
You have the right to require the prosecutor to prove your guilt by proving each element beyond a reasonable doubt. The right to question any witness that's called to testify against you, the right to subpoena witnesses that will testify on your behalf. You understand that? Are you willing to give up those rights to plead guilty to the amended charge?
Yes.
Anyone promising you anything not stated on the record to get you to do that?
No.
Have you been threatened in any way to get you to plead guilty to the amended charge?
No.
Are you currently on probation or on parole? You understand that a guilty plea could result in the conviction that you may need to report to a current or future employer.
Yes.
It also could have impact on where you can travel or get immigration status. You understand that? Okay. As to the amended charge of animal cruelty to one animal, amended to attempted animal cruelty to one animal, how do you plead? Factual basis, please.
Thank you. Mr. Johnson, back in May through July 2024, were you in ownership of a dog in Lincoln County?
Yes.
And at that time, did you fail to ensure that it had adequate food, water, and care in that time frame?
Yes.
It was your responsibilities under the job to ensure that, correct? Yeah. Thank you.
People were satisfied.
The court is also satisfied with the factual basis on such plea and finding your plea to be freely, voluntarily, and intelligently made. Sentencing is going to be June 30th. And we'll get a status from probation as to his eligibility for HIDA. Any additional matters for today's?
Nothing
work?
wrong with people, Your Honor.
I'm sorry, Your Honor, what time on the 30th?
9 a.m.
Thank you.
Any additional matters?
No, Your Honor.
None from the people, Your Honor.
Thank you, you're all set.
I actually have to bring up Mr. Johnson. He is wondering whether or not the court would consider amending his bond to allow for release. He would potentially, if the court is amenable with tether.
People opposed the amendment of bond, Your Honor. And it has gone since 2024.
You're not telling me. I see how many purple failure to appears and remands. I've been trying to track this boy down for 2 years. Now we have several bond violations on top of 1, 2, 3, 4 files for him.
Thank you.
I will continue as is. You're all set. Okay, that's all we have before the jury. Correct? Oh, forgot he was on the team. Who? Shanko. Shanko thinks he can come to court when he feels like it, and I'm supposed to address it. He's been here. He just 8:30 later, much later, because I didn't step off this bench until I think it was 9.
I guess that was my question, that we were able to address. Despite his
Mr. Shanko, why are you late?
What was that?
Why are you late?
I forgot about it.
You forgot that you had court for an assault and battery where the victim is your grandmother.
Yeah, yes,
Is that what you want to believe?
that's the truth.
Oh, okay. He can appear in person. Then when you appear in person, it helps you generate brain flow.
Okay.
Any other matters for today?
That's one that, are you asking to come, are you asking to come today? Or
Yeah, he can come today
Okay.
if he wants to warrant washed.
Yep.
His grandmother was here today in person.
Mr. Schenkel, you have to show up here in person if you want to address this. Are you able to make it to the court today?
Maybe.
Godspeed.
Thank you. Well, I will call, and it's important to note that if you do not show up, this bench warrant is going to continue to be submitted. So it's ultimately up to you if you want a bench warrant or not, but you should come up here as soon as possible.
I don't know how I'd get there.
Or a bench warrant was already issued, but the only chance you had to quash it is to come up here today.
Hmm. Well, by what time?
As soon as possible.
I guess Okay, yeah, I got the address right here. Okay. 6th floor, City Hall.
I'm on there too, okay.
I have to come in person?
Yes. Can you do that? And when will you be here?
Dang.
Okay, I think we're done here.
Like slow or something.
Like for
Exactly. Okay, very good. All right, ladies and gentlemen, good morning for the next 13 minutes at least. If you can fix your attention to the screen, I have some preliminary jury instructions. Ladies and gentlemen, I am Judge Kristen D. Simmons, and it is my pleasure and my privilege to welcome you to the 54A District Court here in Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of our free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in the trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain numbers of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualification to serve as a juror in this case. If you have a religious belief against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. So all the jurors can please stand. Raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as a juror in this case? If you do so, you signify by saying I do. I do. Thank you. I will introduce my court staff. To my right is Miss Addie Nash, that is my judicial assistant and court reporter. To my left is the court officer, Mr. David Warnsley. This is a criminal case involving the charges of animal cruelty or abandonment, which I will explain more fully later. This charge has been made against the defendant, whose name is Trisha Daniels. The defendant is represented by attorney Jessica Straub. She does have co-counsel, which I was just advised of. That's why her name's not here. Please list any witnesses you anticipate calling at trial, and you can introduce yourself and co-counsel.
I'm sorry, could you repeat that?
Introduce any witnesses you anticipate calling and introduce your co-counsel.
Absolutely. We do intend to potentially call Ms. Daniels today. That could change throughout this process. I am Jessica Straub, and this is my co-counsel, Yara Khalil.
Thank you. The prosecuting attorney on this matter is Assistant Prosecuting Attorney Dan Smith. Can you please introduce yourself and then list any anticipatory witnesses for this trial?
Yes, thank you, Your Honor. My name is Dan Smith. I'm Assistant Prosecuting Attorney for Ingham County. Today, I will potentially be calling 3 or 4 witnesses. I'll be calling Mr. Vasquez, a person who witnessed this incident. I will be calling Officer Jablonski from the Ingham County Animal Control, and I may also call Dr. Garrett. She is a veterinarian with Ingham County Animal Control.
Can we have Mr. Vasquez first name, please?
Gustavo.
Is that, it was those 3 witnesses?
Yes, those 2
Okay.
witnesses.
Okay, does anyone in the jury box or anyone waiting to potentially go to the jury box know the defendant? Does anyone know the lawyers?
I went to law school with Yara. Hi.
Okay, awesome. Anyone else know the lawyers? Is that- Well, I know there's an attorney on my list, so let's see here. That's McKinsey?
Yeah.
Kassan. Okay. If you get, I don't perceive that to be an issue, but if you get into the jury box, we'll address it at that point. Okay, anyone know the witnesses? I know we just mentioned names, but there is an Ingham County Animal Control Officer. Is it Catherine or Caitlin?
Her name is Catherine.
Catherine Jablonski, anyone know her? Okay, and then a doctor, the veterinarian, Dr. Garrett. Okay, and then Vasquez, first name again?
Gustavo Vasquez.
Gustavo Vasquez. No one knows the witnesses. Okay, very good. This trial should complete today. If you believe that the length of trial will be a real hardship for you, please raise your hand. Very good. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have any medical problems that make you unable to sit for 2 to 3 hours at a time? We won't sit for 2 to 3 hours at a time, but that's just the jury instruction. Okay, you will get a break. I try to do it at every hour or when it's feasible to take a break because you don't want to throw off their questioning. Does anyone have any sight or hearing problems? Raise your hand if you can hear me. Very good. This is a criminal case. The paper used to charge the crime is called a complaint. A complaint in this case charges Tricia Daniels as follows. Count 1, animals abandoned and cruelty 2 or 3 animals on or about March 1st, 2025 through and including March 3rd, 2025 at the area of 1202 Parkview Street, Lansing, Michigan, allegedly did fail to provide 2 or 3 animals with adequate care contrary to MCL 750.504B. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal case so that the defendant and jury can hear the charges. You must not think that it is evidence that she is guilty or that she may be guilty just because she was charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that's based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable. After a careful and considered examination of the facts and circumstances in this case. You may begin your voir dire.
Thank you, Your Honor. Good morning again, it's afternoon now. My name is David Smith. I represent the state of Michigan, prosecutor with Green County. I want to thank you all for being here today. I know some of you had to take off work. You probably have a little bit better things to do than jury duty today. So thank you. This, as you heard from the judge, this portion of the case is jury selection. This actually happens to be one of my favorite portions of trial because we get to speak with members of the community, hear your perspective on different facts, different elements. Here, that's all day. I see facts in the case, so I believe they say a particular thing is this opportunity to get your feedback and see your perspective on a thing that is help us make this trial better. So I encourage your participation, and hopefully I don't have to put anyone on the spot. If I do, I don't need to do it. So I'm going to first start off by asking, has anyone here ever served on the jury? You have. Just one. Was that a criminal case or a civil case? It was a criminal case. And can you tell us a little bit about your experience with that?
Honestly, I don't recall back to the cases. Probably back in the 80s. I remember it was a case.
Was the Mason? Was the outcome of that case a guilty or not guilty? Do you remember? Don't remember? Okay. Well, for everybody else, hopefully this is one of your bucket list items, and you can check that off the bucket list. And I'm happy that I'm here and I'm included in that story with you. So so no one else has served on the jury. Has anyone, or does anyone view like court TV or crime shows? Anyone think just what's your favorite one?
My wife and I watch a lot of Judge Judy, but I like the mysteries that are on TV. Blue blood stuff.
So Judge Judy, she doesn't have jurors. So my next question was going to be, just based off your experience with anything in your past, what can anyone tell me, or maybe you can start off with you, can anyone tell me what the role of a prosecutor, my role as a prosecutor? Someone else want to take a crack at it?
To represent the government, the state.
No idea.
Prove that she's guilty.
What's that?
Prove that she is guilty.
Prove that she's guilty, okay. Yeah, so, I work for the once charges are filed, they come to our office. Our office takes a look at the case. We see if there are sufficient facts to go forward, and then we present that case to a jury. So that's my role as a prosecutor. And today we are here for, as the judge said, an animal cruelty and neglect. Before I get into the specific details about that, I want to talk to you about your experience with animals. who here by show of hands has a pet? Juror number is that 6. See if you can count. Juror number 6. What type of pet do you have?
I have 4 cats and 2 dogs.
I jot down little notes and I just want to remember, just associate you specifically with something you said. So who else had pet? What other pet? do you have? Two cats and a dog?
Yeah.
I grew up with horses and hunting dogs. Right now I have one small dog.
And
I have one dog.
one dog. For those who have pets, your dog, what breed of dog is that?
The dachshund types.
What about your dogs?
I have a golden retriever and the Shih Tzu Yorkie mix.
Dog?
Staffordshire Vulture.
And you said you have a small dog. What breed is that?
Carrie.
Are you familiar with indoor breeds versus outdoor breeds? What would you say your dog?
Indoor.
Indoor. What about yours?
Could be a dog, but he's indoors.
Indoor.
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 What makes him an indoor dog as opposed to an outdoor?
Oh, and how they're bred if they're able to kind of stay outside. I don't know a lot about it. But that's just something
Anybody else? Yes, you don't have.
No.
No pets? You never have pets?
I've had,
Goldfish? Nothing?
I've had dogs.
Your dog. What? So how do you tell the difference between an indoor dog?
I would say that it's like the breed, the environment that they are from, what they can withstand, what they can hold. Like I would say a husky can be outside longer in the winter than my Shih Tzu Yorkie, right?
How long, you said outdoors in the winter, how long typically would a dog be? You think a dog would be okay outside? in the winter?
Like my dogs?
Yeah.
Just enough to go potty.
What about your dog? What's your dog name?
Gouda.
Gouda. Isn't that a brand of cheese? Gouda. How long can Gouda be outside?
It's really cold. When I get to
So we're here today again on an animal abuse. So when you hear that charge, what instantly comes to your mind? Okay.
caring for them properly, ensuring they have everybody to have a healthy and successful environment.
What about you, Joe, number 1? Been a little quiet over there.
I actually am looking for one.
Are you doing research before you?
I am. I don't know what kind. All my friends have pets, especially dogs, and I want one. Me living alone and I just think they should take care of my children.
Okay. So, again, when we say animal cruelty, like you got a couple people.
Not providing proper care and making sure that they have enough water, food, environment where they can thrive. I've certainly taken to that. The checkups, that's a good thing.
And this case is going to involve animal control, any kind of animal control. Has anyone here ever interacted or had an encounter with animal control?
Very briefly, just my thing, like the lost or stray dog and reporting it to them.
Yeah, so you report it, okay. Anybody else?
Can you speak up, Mr. Smith?
Okay. Hopefully you all can. Yeah, okay. Yeah, so yeah, speaking in that more direction. So you all said a couple things about what we need to prove to establish animal cruelty. So I have a burden of proof in this case. As a prosecutor, I have burden of proof. The defendant doesn't have to prove anything, right? I have to prove, I have a job proving each element in this case. And I could prove that based off of evidence, right? Does anyone know from crime shows or any other experience in your life, what are the two different types of evidence in the criminal case? Anyone know? What's the one? This one?
Let's go with circumstantial.
Almost. Circumstantial was one of them.
Actual.
Direct and circumstantial evidence. So take another stab. What's the difference between direct and circumstantial evidence? Anyone?
Direct video.
Yes, video. Anybody else?
Circumstances more sort of a logical construction.
Yes, it's the type of evidence where it's presented to you where you can reasonably infer something from that evidence. Direct evidence is more got your video, direct a testimony from an eyewitness, a direct person who saw it. If I give you a photo that's directly taken, if I could give you some evidence where you have to draw a reasonable inference from that evidence, that's called circumstantial. Now, does anyone know, based off of what we just explained there, which one of those types of evidence is more valuable in this case? Direct or circumstantial?
Direct.
How many say direct? Direct?
I can't say either without hearing the evidence. You ask me which is more valuable. I can't place a value on something that I have no knowledge of. So I can't say the direct or circumstantial.
Which one of those do you think would help me prove my case more? Direct evidence? Okay, so based off of that, which one is more valuable? Direct or circumstantial?
I'll say direct.
Correct. Well, I admit I just fooled you a little bit because the answer to that is the both should be given the same weight. Both direct and circumstantial, you can give the same weight to that type of evidence in order for you to help you decide the outcome of this case. So, with those two particular pieces of evidence, I have the burden of proof. Has anyone ever heard of my burden? What do I have to prove here? What's it called? My burden of proof. Has anyone heard proof beyond a reasonable doubt? What does that mean to you? Beyond a reasonable doubt.
Yes, absolutely.
Absolutely, 100%. 100%. Okay. Who else? proof beyond a reasonable doubt. What does that mean? My verdict. The evidence that I'm gonna put before you, with both direct evidence and circumstantial evidence, that's gonna help you make your ruling today. I have to prove it beyond a reasonable doubt. So what does a reasonable doubt mean? You said that evidence has to prove that the defendant's guilty 100%. Who agrees with? Who agrees? 100%? 100%. So if I told you that a reasonable doubt does not mean 100%, would you take issue with that? Anyone? So the judge is going to give you some instructions, and she's going to tell you exactly what proof beyond a reasonable doubt means. Does not mean 100%, because we can't be 100% certain about anything, right, in life, right? I remember a time where I take my medication every day, like clockwork, right? But then I go to the office and I'm thinking, well, did I take my medication today? But I know that I do it every day. So even the things that you do yourself, witness yourself, see yourself, it's hard, often hard from something 100%. And that's not my burden. My burden is beyond the reason. And essentially what that means is at the close of this case, when both IRS and the defense rep, I'm going to need to give you enough evidence. Find a defendant, I'm going to need you to give enough evidence for you to be reasonably sure to a degree that you would find something, a matter of importance in your own life. You will be comfortable with making that decision. That doesn't have to be 100%. Right? You just have to be comfortable with that evidence to enough degree that you would make a reasonably informed decision in your own life about what that evidence concludes. So, does anybody have an issue with that? With that? Holding me to that standard. Would anybody have an issue with holding me to that standard?
Okay, thank you. Thank you.
So I think the judge asked already, but no one here knows me personally, right? Has anyone had an interaction with the Ingham County Prosecutor's Office? Anyone from the Ingham County Prosecutor's does anyone know anyone from the defense attorney? Is anyone friends with someone from the Ingham County Public Defender's Office?
No.
Again, does anyone know anyone from the court personally?
No. Got it.
Yes. Okay.
So final question is, does anyone have any concerns about ruling the case on animal cruelty and neglect? Does anyone have an issue with your testimony? Tell us.
I observed animal cruelty and neglect. And to my father on our farm, field trials.
Was that experience in any way your decision would you still be able to reasonably listen to the evidence and make a conclusion based off of the evidence and the testimony, as opposed to your personal experience?
I'm not sure. I'm just being honest. I'm not
Okay.
sure.
Okay, thank
I'm
you.
feeling emotional at the idea of having to relive someone possibly neglecting or abusing animals.
Thanks for your honesty.
Like coming up, dogs, young cat. About 3 years ago, I was living with my son and his family. They have since moved to Texas, but they did have Zeus. And he's a husky. And he was just close to our family. It's part of the family. I also have friends that are very close to their pets. And I can't imagine being cruel to an animal, especially a dog.
Well, at this time, the defendant has the presumption of innocence. Right now, she's been charged with those are just allegations. We're here today to determine whether or not those allegations are true. So again, it's my job to put evidence before you to prove those allegations true. As she sits there right now, she's innocent.
Absolutely.
So with your past experience that you had, would that affect your ability to reasonably listen to the testimony that you're going to hear today? Then after that, make an informed decision, reasonable decision based off the evidence that you heard about the defendant's guilt or innocence.
I don't think so. I don't think I'll be able to. Just the thought of it. I don't want to see any pictures. I don't want to, just the thought of it. I can't imagine hurting an animal, especially dogs.
Thank you for your answer. That I have no further questions.
Well, I think we have now officially entered the afternoon. So good afternoon, everyone. I'm just going to piggyback just a little bit on what Attorney Smith mentioned relative to how important your duty is today. I absolutely appreciate you being here and sharing your time with us. I simply ask that you give us your undivided attention. Okay? I similarly am going to ask you a series of questions. Raise your hand for me if you have ever been a witness in a case. Thank you. Tell me a little bit about that.
I was a character witness.
Okay.
It was back in '80s.
Okay.
And it was for a debate coach who was accused of improper conduct.
Okay. And was it, were you a positive?
I was, yeah, there was like 40 of us that were up here for this in favor of the
Okay. Okay.
support.
Okay. Thank you for sharing. Yeah.
In New York State, and I was kind of complicated, but I was a witness for an organization that had a booth at the 20th anniversary of Woodstock.
So as you were a witness, tell me a little bit about what you felt like your duty.
To give my opinion, my view of how this man's character is.
Okay. So based on your own personal.
My own personal.
Okay.
Affirmation.
Did you take note?
Yes.
Okay. And was there also a duty to be honest?
Yes.
Okay. How about you?
I just remember I was there to answer questions.
Do you recall maybe what you felt like your responsibility was as the witness?
To respond to the questions honestly.
Okay. Have any of you ever been a party in a case? So either you sued someone or you got sued or anything like that? All right, I'm going to switch tracks a little bit here and ask you a little bit about law enforcement. Okay. Do you believe that law enforcement can be mistaken in their conclusions?
Yes.
Yes. Okay. Do you think that they can potentially misunderstand a certain case? Yes. Okay. What would you expect from an officer relative to investigation? How thorough would you expect an investigation to be? I'm just looking at you. You're kind of reacting, so I'm not trying to target you, but
yeah, just doing the job that they're expected to do, that the community expects them to do. Safe and helpful laws, so do a thorough investigation.
what would you say is a thorough investigation? Like, what are some of the things you would expect to hear an officer have done in their investigation?
Look at past history, and the scene, maybe asked neighbors or other people about the situation, what they've noticed, things like that.
Okay. Would you also expect to see evidence? Okay. What kind of evidence did you expect to see? I promise we'll move on. I promise. I promise.
Photo evidence and the testimony, conversations that were had.
Okay, well, specifically in a like an animal cruelty case, what kind of evidence would you expect?
Evidence maybe from like pictures of the living situation that they're in. If they had like a vet check out the animal to see whether there was anything that was wrong with them, did it prevent it, or what they were receiving.
Okay. You said photographing. What about video? Anybody want to add to that? Anything that maybe wasn't mentioned that you would expect to see in a thorough investigation?
Witness interviews.
Witness interviews. Okay. Okay. Thank you. Okay. Talk to me a little bit about associations. Does anyone here, have you ever worked for an animal shelter, a rescue group, a veterinary clinic, animal control?
No.
I have one of my best friends is the owner of that clinic.
Okay.
So when he was starting out, he would be on call, and occasionally I'd go with him to the clinic or something.
Okay. Describe your experience when you went to the clinic.
It was somebody's cat or dog that was hit by a car, and he had to put it to sleep, which was very sad. He was also the vet for the Wayne County Sheriff's Department.
Okay.
So he took care of the horses. So we would occasionally stop in at them.
What about animal welfare organizations like PETA or HASIS, local humane societies?
I had a dog that got eyes for the blind.
I'm sorry, could you-
I had a dog that I fostered for guiding eyes to the blind.
Okay.
For puppies, or guide dogs, sniffers.
And how did that dog come into sort of the foster care system? Was that always like, was that dog always intended to be? Okay, understand.
She was supposed to be a guide dog, but they pulled her because of excellent physical attributes.
Okay. All right, I'm gonna switch tracks a little bit again here, okay? I want you to talk to me just a little bit about the defendant not testifying, and maybe why that would be the case. What are some reasons that an innocent person wouldn't testify in their own trial? And I hate to just say that, but I'm gonna ask you.
Yeah, that's fine. Probably because they feel like the evidence doesn't prove their guilt. They don't want to.
Great observation. Anybody else want to add to that?
They didn't actually do it.
Guilty. The way they answer the questions.
Wondering what your thoughts are. Jury number one, wondering what your thoughts are.
I think that I wouldn't want to testify at my own trial because the attorney knows more than with the school.
Okay. What about stage play? I mean, standing in this position right here, right now, I might be able to say to that just a little bit. What about the fear of the cross-examination process? I mean, we've all watched the legal shows, right? What about that? What about when the attorney says, I don't think you should? Right? Okay. I want to circle back just a little bit to the proof expectations. Attorney Smith did a great job explaining who carries the burden of proof in this case. As he mentioned, judge will give us the law, okay, so we'll follow what she says. Let's talk a little bit more though about the definition of beyond a reasonable doubt. Okay. I think you mentioned 100%. Vince attorneys love this. But I do think Attorney Smith circled back a little bit, right? If I were to say that the prosecution today must prove my client's guilt so clearly that no rational person could doubt it based on the evidence, what would you say? Sounds logical? What about you?
Can you repeat the question, please?
Absolutely. If I said that the prosecution today has to prove my client's guilt so clearly that no rational person could doubt it based on the evidence, what would you say?
That would probably be a guilty verdict. Or not guilty verdict.
So I mean in terms of how to define beyond reasonable doubt. Okay, and I'm saying that the definition is that it has to be so clear that no rational person could doubt it based on the evidence. What would you say in response to that?
Sure, yeah.
Okay, you can accept that?
Yeah.
Okay. What about you?
reasonable doubt means. I honestly don't know. I mean, what that means to me. I'm understanding it here, but
Well, when you do introspection, what does it mean to you? Notwithstanding what we've said, Mark, check that. What does it say to you?
yes, I've been trained to doubt. People being adamant about something.
Anybody else want to talk? All right, my last question now. And I'll put you through the ringer. Thank you for dealing with me, putting up with me. If the odds today are 5-1, meaning that everyone else on the jury but you believe that my client is guilty, will you be able to hold your ground on your conclusion? Yes.
Yes.
Even if everybody's really mad at you though? Even if they're like, come on, I'm ready to go home, I'm tired of this. You're still confident?
Yes.
Okay. Thank you for your conviction. That's all right.
Thank you. Okay, Mr. Smith, any challenges with cause?
None from the prosecution.
Ms. Strong, any challenges for cause?
Yes, Your Honor. The defense would move to strike both jurors number 1 and 3 for cause.
Based on what?
Based on the fact that they show a state of mind that will prevent them from rendering a just verdict, or that they've formed an opinion on the facts of the case.
I don't believe that's what juror number 1 was saying. You have an opinion on the facts of the case? Do you know the facts of the case?
Well, I said, I'm sorry, I meant with
Ma'am, I'm questioning juror number 1.
I'm sorry.
Did you know the facts of the case, ma'am?
Not yet.
Okay, so what is your
I was just
opinion?
saying
What,
I
no,
wanna talk.
I'm asking a direct question. What is your opinion on the facts of the case then? Yeah, because you don't know the facts.
Right.
Okay, and then my understanding is your number 1's position is that she can't imagine anyone being cruel to an animal. She would not like to see pictures. That's not a state of mind that makes you impartial or unfair. I can't imagine anyone being harmful to humans. I don't want to see pictures. Does that mean that I can't be fair and impartial? Are you saying you can't be just and fair because you can't imagine someone being
have to
harmful?
be fair.
I'm sorry?
I have to be fair.
No, not that you would have to. Do you have the ability to be fair? If you're telling me I don't have the ability to be fair and hear the evidence fairly, that's one thing. But just telling me that I can't imagine someone harming an animal, that's not telling me that you're unjust or that you're not impartial or fair.
No, I'm not unjust at all. I was just saying that to visually see a picture or even hearing about this right now, I've never experienced that before. And I'm an animal lover.
Do you love humans?
I do.
Do you believe humans have rights?
Absolutely.
Do you believe the human have a right to a fair trial?
Absolutely.
If you were in this position, would you want fair jurors?
Absolutely.
Do you believe that you are a juror that you would want to sit there and listen to your case fairly and impartially?
Yes, I would want somebody to be.
Not somebody, I'm talking about you. Do you believe you personally, your mindset is, I would want someone with my mindset to judge the matter for me if I were sitting in her seat? Is that your belief?
I would never do that. I would never.
Do what?
Go against.
Never do what?
She's going through, because she hasn't been even on the trial yet. So I can't make a judgment. Oh, I don't want anything to do with it. I don't know if she did it or didn't do it. I was just saying my opinion as far as.
No, but you're not answering my question. What was my question?
If she was sitting in my position.
If you were sitting in her position, would you consider yourself to be a fair and impartial juror? Like if you switch seats?
Yes.
Okay, and you would be the type of juror that you would want to hear yourself have a case before? Your mindset? Or do you believe that you are unjust in your thinking?
I can't say that if she's innocent, guilty, or guilty.
You can't say.
We haven't.
What do
I
we?
wouldn't do that.
No,
Because I-
you can't, who can't say if she's innocent or guilty? Raise your hand if you can say, as of right now, if she's innocent or guilty.
We
Ma'am,
know she's innocent.
that's the law. She's innocent. Who told you that?
Yes, I learned today.
Until proven guilty beyond a reasonable doubt. You've heard no evidence, so you don't have
Right.
anything to judge her against. Just the idea. And I also read that just because I read a complaint, it's not evidence. You hearing that she's being charged with something does not make her guilty. That's not evidence. Are you able to process that?
Yes.
Okay. And then what was your issue as to juror number 3?
I do think that she's pretty consistently indicated to the court that she has already formed an opinion and that she's not going to be able to be impartial today.
Formed an opinion about what, ma'am?
I have not formed an opinion about this person. I knew.
About animal cruelty, is what you mean? You formed an opinion about animal cruelty?
No, I said I have not formed an opinion about her.
I get it. Have you formed any opinions? Because she said that you've already formed an opinion. So I'm trying to understand what opinion have you formed, if any?
My experience is that with the people that I had experience with abusing animals is that they would tell anyone that the animals deserved it or it was discipline.
That's not formulating an opinion. So what specifically are you referencing?
I do believe that she mentioned, Your Honor, that she observed animal cruelty as a child and said that this will sway her decision absolutely.
Okay.
So
Is that you recall that as your statement?
I said that I'm having strong emotions.
Because
as
it
a
could
father.
trigger, is what you're saying.
I'm having strong feelings about re-experiencing what I observed as a child and hearing about that in this moment.
But you haven't heard
That's
any
what I said.
facts about anything, so you don't, so how are you having strong feelings about what happened in your history if you have not yet heard any facts?
No, I said I had strong feelings about hearing a story about animals being abused
Okay,
and
got it.
neglected.
Okay, I understand that. Counsel?
So people would object to the court calls striking of either two jurors. So I believe they want to use a peremptory strike, and I would obviously have no issue with that. I would object.
Thank you. Your objection is noted. As to juror number 1, I think that she has a mindset that we can't overcome. Because I don't think she understands that the defendant is innocent until proven guilty. But also, I think she's also formulated a belief that she wouldn't be able to overcome and fairly judge the evidence. So for that reason, I will grant the challenge for cause as to juror number 1. Thank you for your service. As it relates to juror number 3, I think that, and again, I don't even know the facts of the case at this point, but just based off of her statements, it could be triggering. And I don't know what it is. So I agree that she has a mindset that requires her to be released as well. So you may be excused as well.
Thank you.
We're going to replace both jurors. Juror number 1. Will be Julian Hudson. Juror number 3, Charles White. Okay. And then once they're seated, Counsel Smith, if you want to proceed with any preemptories.
You said Charles, right? White? Like
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 L-E-I-K. Hudson, and then what? Okay, any preemptory challenges?
Not now.
None, okay, any preemptory?
None, Your Honor. Thank you.
Okay, you can voir dire the new jurors.
Again, for being here, I think you've said through most of it, so we will go over everything again. But you have to ask you a couple questions. And I don't, I'm not being rude to the rest of you, but you're seeing you did so far, so you know, we really talk to you. So don't take the questions that I'm not talking to you. Okay? So turn number one, turn number three. So again, I'm gonna ask you some questions that you probably already heard before. Please don't take it as a fine. This is how the process works. So we started off by asking, have you been involved on the jury? Have you been on the jury? What type of case? Assault and battery. Assault and battery. A criminal case. Tell me about your experience with that case.
I mean, it was pretty open and shut. It was very empirical and went through the different elements, which we went through both of them. That was that.
So was there a guilty finding in that case?
Yes.
And tell me about, so you probably understand the reason about. Some people have a little bit of hard time understanding the reason about. So school. I'm going to give you some testimony. You can put on some evidence, put on some witnesses. And those witnesses are going to provide you with either direct or circumstantial evidence. We spoke earlier that there shouldn't be more weight given to one than the other. It's an equal amount of weight, direct testimony and circumstantial evidence. So direct evidence and circumstantial, right? So, and in the conclusion of that evidence and that testimony, you're going to have to make your finding beyond a reasonable doubt. So you're kind of involved in it once before. So tell us what that means for you, the time where you made that decision.
So we had basically video and like actually even the defendant saying that they basically matched all of the elements. So it's pretty much an open and shut case.
So does every case require the defendant come on and tell, or does every guilty finding require that amount of evidence? And for me to prove beyond a reasonable doubt that the defendant is guilty of the crimes that are charged?
No, I would think that was a very odd case.
Okay. So what does specifically beyond a reasonable doubt? But again, what does that mean? I mean, your understanding of it.
So it's not like mathematical possibility. That's not what it means. That is, if you had to bet the farm on it, you would bet the farm on this is true. Could you be wrong and lose the farm? Yes, but you would bet the farm on it. You want to take that in. I guess, yes.
Right? So yeah, but essentially that's what it means.
Yeah.
Right? It means, hey, I have an important decision to make in my life. I'm going to go out and I'm going to research this thing. I'm going to get out this. I'm going to listen to testimony. And after all the evidence is, you collect all that evidence, I'm going to make the best decision that I can based off the evidence that I have. Am I comfortable with finding guilt based off the evidence that I have? So if it's like, let's say if God forbid, if someone had a life-altering surgery, right? And you need to make a decision with which doctor you go with. That's a important decision in one's life, right? You go out, you do research, and you're set on this particular doctor, right? The evidence that I present, kind of that beyond a reasonable doubt means something close to that. So after you get all that evidence, you listen to that particular doctor, you research the illness, you collect all this evidence. After you've done that, I'm comfortable with going with this doctor for my important surgery. And that's kind of what I'm beyond the reasonable doubt. And it can't be 100% certain because there's a degree of uncertainty with everything. Right? But if you are comfortable with making that decision, as if you were making an important life decision, as in a surgery or picking a school, college for your kid, or deciding whether or not to have a child, you have to be that comfortable with at the conclusion of this evidence that looks that. So, Turner, what do you? What is your opinion about that? Do you have pets? Were you a pet owner in the past? I've never had cats. What happened?
Can you speak up, please?
Usually it's like a car, something bad, but we used to.
So you just had cats in the always all pets. Okay. Livestock. What about you, Jeremy? Did you have pets?
Growing up, I did, but once I moved in the city, apartments don't really like them, and my daughter's definitely afraid of dogs, so basically not an option.
What type of pets did you have growing up?
We had a dog and some cats.
Was your dog an outside dog or inside dog?
Outside.
Outside dog? What breed was your dog?
It was sort of a mutt, just a mix of a bunch of different breeds. I'm not sure what it really was.
What's the difference? The difference between an outside dog and an inside.
Right. So, like for example, they're husky will survive the cold. Chihuahua will not survive the Arctic Circle. So it depends on what the environment is. For example, you don't want to take a husky outside in New Mexico, Mexico City, because it will probably die of heat or something, because it's meant for Alaska. So it just depends on what environment you're in and what the dog is meant for.
Do you have any, have you ever had any interaction with any county animal control?
No.
Do you believe that you can judge an animal cruelty case there? Yes. When did you say the last time you had that? Years ago. Okay. The reason why you don't have pets now is because you moved away from the farm. Yeah. You live locally here in Lansing. Do you have any plans on getting pets in the future? No. Why not?
When you had this,
We cannot hear him. Every answer has to be heard on the record, and we can't hear you.
sorry about that. It was just when you had several pets die in 2010.
And you said your actual, you said on the farm you have livestock, but your actual pets were cats.
Yes.
Right? And then you grew up with dogs.
Cats.
Cats. Give me a couple examples of animal cruelty. When you hear that charge, someone's been charged with animal cruelty. Second you hear that term, what pops into your head?
What pops in my head is like people torturing acts, like more of the being abusive for them, like physically. That's what just pops in my head. I know it can encompass other things. It's like I haven't seen the actual definition of the tenets of it.
But you haven't seen the definition, but can you think of any more things that might be?
Yeah, I mean, like there's neglect, there's physical abuse. I mean,
what does neglect mean?
well, like for example, you see like an animal that's completely emaciated because it hasn't eaten, it doesn't have access to water, things like that. It also, for example, if it overheats, you could have neurological issues where it's then acting odd because it's overheating. Like there's lots of different things that people encompass it.
Could too cold be one of them?
Yeah, exactly. Like I said, the troll in Alaska would be bad.
What about you?
Animal, the first thing that pops into my head is those puppy mills.
Those what? I'm sorry.
Puppy mills.
Remember the judge said you have to keep your voice up a little bit.
Yes, the puppy mills where they're like, tiny cages, and not treated well.
Aside from that, you said you lived on the farm, and you had cats. Were there some other things that you consider would be improved to my cat? That's cool to this cat.
Yeah, so I mean, one thing that we always had to do on really cold winters is make sure that all the animals were inside because frostbite was a real concern.
To both the livestock and your cats?
Yeah.
Okay. And then you wouldn't have any concerns about judging this particular case fairly based off the evidence that you can hear from the witnesses.
No concerns.
Okay, thank you very much. Appreciate it.
Just a couple of questions for you. Do you belong to any welfare organizations, animal welfare organizations? What about any advocacy groups? I'd like to know your thing, a little bit about the defendant not testifying. I know we talked about this, but there are probably other reasons why the defendant might not testify. Can you think of any?
That's the prosecutor digging at you and so you would not be too helpful with your case.
Much to just over in this points, like they might attack your credibility, and then even though you're trying to defend yourself, it might actually backfire.
What if I were to tell you that Ms. Daniels does not have to testify and you can't use that case?
Status quo is it?
Sorry?
I thought that was the status quo for most defendants.
I think that's a fair assumption, yeah. And I'm sorry, could you repeat what you said?
It's the Fifth Amendment.
And what is that? What does that do?
Silence. So you don't accidentally incriminate yourself or it's construed.
Would you assume that someone is guilty if they don't testify? You mentioned seeing empirical evidence in the trial that you participated.
Right.
Could you tell me a little bit about, I know you mentioned videos and I know you mentioned the defendant testifying themselves. Give me some other examples of empirical evidence that you saw.
Well, empirical is
So it was it was footage inside the bar, and then it was the body cam footage by the officer who was interviewing the defendant. And then there was pictures based on injuries that were also presented.
Okay. What would you say, you mentioned that neglect could potentially be, a couple of examples you gave, I think, were dogs looking emaciated or animals being beaten, things of that nature. What are some other things that you might expect to see, especially in a case where there's cross-eyed, for example? Take a picture to it? Okay. Well, I gotta ask my favorite question. If you were, if the odds are 5-1, you're that one, you're the only one holding out on not guilty, and everybody else is assumed guilty, could you hold out?
Yes.
Even if everybody's mad at you, you're ready to go home and eat, even if your stomach is growling? All right, thank you.
Challenges for cause. Any challenges for cause?
Not at this time.
Any preemptory?
None from the vehicle, Your Honor.
Any preemptory?
No, Your Honor, thank you.
Okay, we're satisfied with the jury. All right, ladies and gentlemen, we have a jury. There are remaining of you that did not get an opportunity to make it to the jury box today. I thank you for appearing today, being attentive and prepared to serve your civic duty. I'm going to relinquish you into the hands and care of my court officer for further instruction. Do remember that you still need to call in to report for the remainder of the week. I think it ends after tomorrow. All right, so the jury. Okay, you all can be seated. I'm going to do a set of instructions and then I'm going to release you for a break. Okay, if you can pay attention to the screen. Ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If you have religious beliefs and they do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If the jurors in the jury box could stand, please. Raise your right hand. Do each of you solemnly swear or affirm that in the action now before the court, you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced in accordance with the instruction of the court? If you do so, say I do.
I do.
Thank you. You can be seated. You will have a written copy of my instructions that I am about to read to you, but you will not get that written copy until it's time for you to do your deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. But first, let's go over the elements. It was animal cruelty or abandonment. The defendant is charged with the crime of animal cruelty or abandonment. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant owned, possessed, or had custody of a dog or dogs with dog or dogs under her care. Second, that the defendant failed to provide the dog or dogs with adequate care. Adequate care means providing enough food, water, food, and exercise, and providing sufficient shelter, sanitary conditions, and veterinary care to keep an animal in a state of good health. I'm not sure why it's giving me these weird spacings. Let's see. Or the defendant was negligent in allowing the dog or dogs, including aged, diseased, maimed, or disabled animals, to suffer unnecessary neglect, torture, or pain. Neglect means failing to sufficiently and properly care for an animal to a degree that the animal's health is jeopardized. Or the defendant either tethered the dog with a rope, chain, or similar device that was less than 3 times the length of the dog from nose to the base of its tail. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about the time frame of March 1st, 2025 through March 3rd, 2025 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's lawyer may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may call or also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender, gender identity or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and then anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witness questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write your question down, and pass it to my court staff, who will give it to me. Do not show your questions to any other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given to answer questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussion out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to those interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone else who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop, explain that you are a juror and you are not allowed to discuss the case. If they continue, leave and report the incident to my court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. Again, for example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside this courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to the court staff. You may take notes during the trial if you wish, but you, of course, do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7 after you have heard all of the evidence and my instructions. We will draw names to decide which one of you will be dismissed to form a jury of 6 for deliberation. possible penalty should not influence your decision. If you find the defendant guilty, it would be the duty of the judge to fix the penalty within the limits provided by law. I may give you more instruction during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken together, they are the law you must follow. After my final instructions, you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives than yours. Okay. It's about 1:20. We need to give the jury a lunch break. So we are going to give you until 1:55 to get back here. So that we can proceed with opening statements and testimony of the witnesses. There is a jury room back here, which is where you all will be able to store your things. And that's also where you'll be able to congregate when you're in the building. Again, remember that there has been an instruction that you have to speak to anyone connected to the case, and you don't know who might be connected to the case. And that means even if it has nothing to do with the case. If you have any questions when you return, you can speak or let my court staff know so they can let me know. You'll also get a sticker, or you have gotten a sticker that identifies you as a juror in the building. We will be in recess until 1:55. All rise for the jury.
It's only right there. Talk to me for 3 minutes.
On the record in the matter of the state of Michigan versus Marquez Washington, 25-03736, appearance, please.
That Robinson, Your Honor?
Marquez Robinson?
Yeah. Back here.
Thank you, Your Honor. Please report Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Marquez Robinson, standing to my right.
Okay, Mr. Robinson had a probation violation hearing scheduled for today for testing positive for alcohol on the 6th of April. How are we proceeding?
Your Honor, he is pleading guilty to that violation today.
Is that correct, Mr. Robinson?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You put your hand down. Okay, you understand your right to have a contested hearing on the violation? And you understand your right to have your attorney represent you and the right to have the prosecution and the probation department bring forth evidence to establish your guilt as to the violations?
Yes, ma'am.
You wish to waive your right to hearing and plead guilty?
Yes, ma'am.
Or threaten you to do that?
No, ma'am.
Any promises if you plead guilty? As to the violation alleging that you tested positive for alcohol on the 6th of April, how do you plead?
Yes.
Factual basis.
Mr. Robinson, were you previously sentenced to a term of probation?
Yes.
And during your sentencing, were you not advised that you were not allowed to consume alcohol?
Yes.
You were advised? Okay. And during that term of probation, did you complete testing at AberHealth?
Yes.
And did you test positive for alcohol?
Yes.
And did that happen on April 6th of 2026?
Yes.
That's all.
People are satisfied.
We're satisfied with the factual basis. I'll accept your plea and find it to be freely, voluntarily, and intelligently made. The recommendation at this time is to continue the probation. Jail not suggested, however, possible suggestion of a scram tether. Since defendant began probation in March with probation officer Bayless before transferring to Mr. Nabb. You can make allocution.
Your Honor, I did have a chance to speak with Mr. Robinson. He was forthcoming in admitting his bad choice of conduct during his term of probation. He is ready to commit moving forward to not consuming any substances. We would ask this court to give him another chance at probation absent the scram tether today.
Let's see, he's on probation until December. We'll continue his probation status at this time. I will not add tether. You were, I think, just placed on a term of probation not long ago, because I just. I just saw you March 6th, so it's like, and so. Do you have questions about your conditions of your probation? So you're clear as to what's required of you? You're clear? Okay. They'll check in with your probation officer before you leave. We'll continue your probation. You're all set. He's not here. Oh, he's not here. You can't check in with him.
Okay.
You'll report on your next regular report date, okay?
Okay.
Thank you. Christopher Wise here. Is Mr. Wise here?
I do not believe so, Your Honor.
Mr. Wise, always.
We can go back on the record in the matter of the state of Michigan versus Tricia Daniels. And counsel, you had a motion to address.
Yes, so, Your Honor, I'd like to address, I think, 2 matters. One is the jury instruction I would move to add the lesser included charge, just the destruction of just cruelty to animals.
Okay, so we can do that at the time of the composites, like, because we'll go over the composites together, so we can do, that's no problem.
And then the second motion, we had a motion to admit prior bad acts.
Okay, which I never seen, so you can make it early.
So this case is again about animal cruelty and neglect. From what I understand, the defendant has had several prior occasions where she's come into contact with Ingham County Animal Control. Ingham County Animal Control came to her home approximately 15 times over the last 2 years in relation to her dogs, the condition of her dogs, and dog at large, tether. They, during those times, offered the defendant some assistance with getting the necessary outside shelters for the dogs. That is some information that Officer Fonzie has direct knowledge of. And I believe it goes to a pattern of behavior as it relates to this dog and neglect that brings us to court here today. In addition to that, it serves as a foundation that the defendant knew or should have known the correct sort of guidelines in order which to keep her dog so she would not end up in court today. So under a basis of just her knowledge of what the conditions were, not to be charged, and as a pattern of behavior of neglect to the dog, I would ask that all the previous interactions with Ingham County Animal Control be admitted at trial.
I have no objection to this, John.
Okay, well, I don't know if any objective in the first place, but
I didn't.
okay. Well,
I never did.
well, I think that makes it easy for you, Your Honor.
Your motion's granted.
All right, so we are prepared.
You can call the jury back. Oh, was. They responded. So they should have mailed it for Brian. Yeah, more than 23. Okay, as to the motion that you just argued, although she stipulated it, the reason why we didn't receive it, because it looks like it was sent to the criminal traffic email, and they responded to Ms. Buckingham with a policy for filing a no more than 20 pages via email or fax. So she was supposed to file it the old school way. It never happened.
Okay.
Are we gonna do it? Great. You wanna? Yeah, I think I meet up by 3:30.
3:30. All right, well, remind me at 3:20.
I got you. All right.
Okay, be seated. Okay, you get to see opening statement.
Thank you, Your Honor, opposing counsel, all members of the jury, and I want to thank you all for being here today. There is an old adage that you should treat others the way you want to be treated. That didn't happen in this case. Again, my name is Dan Smith. I'm Eagle County prosecutor, representing people in the state of Michigan. And obviously, as you know, we are here today on an animal cruelty and neglect case. And before I get into the specific details of the case, I want to share a little information about the alleged victim in this case. If you haven't already guessed, you probably guess now that this the alleged victim is not a person, it's a dog. That dog, there's two dogs. One's name is Hoghead Cheese, and one's name is Malachi. Hoghead Cheese is a Spanish Raza Canaria, is how you pronounce the breed. That dog has a short, dense coat, and that dog, on the day in question, can be seen reacting to inflammable coating. You're going to hear testimony today that on March 1st, 2025, last year, there was an individual, neighbor, who had rented a Airbnb. He was living across the street from the defendant, and he heard barking for hours. And he saw Hoghead Cheese, this Spanish breed, outside, locked in a wire cage for hours on end, barking, barking, barking. After hours of barking, he became so concerned with the health and safety of this dog that he contacted Ingham County Animal Control, and he reported a welfare check. He wanted someone to come out and check on the welfare. That report was done on a Friday. Ingham County Animal Control did not receive a report until Monday. And we're going to hear testimony from Officer Jablonski of the Ingham County Animal Control that when she arrived to the defendant's house on Monday, that the dog was still in that same wire cage, locked up, barking, in freezing weather, and it was shivering in reaction to the cold. You're going to hear Officer Jablonski tell you that she attempted to make contact with the defendant while she was there. She stayed in front of the defendant's house for approximately 45 minutes, knocking on her door, trying to get her to come out and take the dog inside. She didn't answer the door. Officer Jablonski had to take another priority animal control complaint. So she left the defendant's house, came back about an hour later. The dog was still in the same cage, still in freezing weather. That second time she came back, knocked on the door, didn't get an answer. She called the defendant because she had prior interactions with the defendant. Defendant knew that she shouldn't keep this dog in the cage. So Officer Jablonski had her phone number. She called. She talked to the defendant. And at that time, we're going to hear Officer Jablonski say that the defendant was inside the house the entire time. She just ignored it. Just ignored the dog. Ignored the barking. So when Officer Jablonski talked to the defendant the second time on the phone for about 20 minutes, the defendant eventually came out and took the dog back inside. Officer Jablonski was gonna write a search warrant to take control of the dog. But again, after 20 minutes of knocking on the door and her finally answering the door and taking the dog back inside, she didn't write the search warrant to take custody of that dog. When Officer Jablonski, again, when she was on scene, she saw Malachi in the backyard. He was tethered to the fence or post in the backyard, and all he had was a plastic igloo style dog cage. That dog cage did not have any straw in it, and it did not protect Malachi from the elements that day. So based off of Officer Jablonski's 6 years of training, what she observed, the information she got from the witnesses who's going to appear via Zoom, hopefully everything will be okay with our technology today. He's going to appear via Zoom based off of his call to Leon County Animal Control on March 1st, and what Officer Jablonski saw on March 3rd when she got to the defendant's house. The defendant was charged with cruelty to animals. In order for you to find the defendant guilty of this charge, again, I have to prove to you beyond a reasonable doubt that the defendant owned one or two of these dogs, and that the defendant, she failed to properly adequately care for the dog, or that her negligent conduct put this dog health and safety in jeopardy. And that's what the evidence is going to show. Hours outside, freezing weather, locked in the cage, that's what the evidence is going to show. And because the evidence is going to show that, closing the testimony, and both sides rest their case, I'm going to come back before you. I'm going to ask you to find the defendant guilty of both charges. There's going to be a charge of cruelty to two or more animals. There's going to be a charge of cruelty to one animal. I'm going to ask you to find her guilty on both of those charges. Thank you.
Larry, you want to do yours now? It's up to you.
People call it Officer Jablonski. Chair. Judge said swearing. Yes.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
State your first and last name and spell both.
Catherine, Kathryn. Maiden name is Jablonski, Joblonski. Married name is Fabius, F as in Frank, Abus.
Proceed.
Thank you, Your Honor. Officer Jablonski, I know it's been a little bit of a long day, so I know you said your shift was ending soon, so we're gonna try to get you out here as quickly as possible, okay? So I'll first start off by, looks like you got your uniform on. Are you currently employed?
I am.
And where are you currently employed?
Ian County Animal Control.
And how long have you been there?
Almost 6 years with this department.
Okay, and what is your assignment at the animal control?
I'm an animal control officer.
Okay, do you have any particular training with and how to react with animals, or did you have training, formal training for that?
I'm an associate's degree in criminal justice. Did my 100 hours of MDR certification to become an animal control officer. A lot of trainings here and there that the department sends you through, a lot of on-the-job training.
And how often would you say you have reacted or investigated or as a what? Let me withdraw. In your job as an animal control officer, do you investigate animal cruelty cases?
Yes, sir.
How many cases would you say you investigated over your 6 years?
10 to 100 or so.
And I'm gonna direct your attention to why we're here today. I know that there's a little bit of background, so so let's go to March 1st of 2020, or March 3rd of 2023. Is there someone present in the courtroom that you came into contact with on March 3rd?
Trisha.
And where's that individual seated? Can you describe where she's seated in the article of photo?
She's sitting to my left, wearing a black blazer, and sweater.
Your Honor, may the record reflect that the witnesses identified the defendant?
Objection.
No.
Identification is needed.
Okay, so that was March 3rd. So what brought you to the defendant's home on March 3rd?
So we received a complaint on March 1st, actually, of a dog being outside in a wire dog crate on the front porch for extended periods of time.
When you say on the front porch of the wire crate, did you take a photo of that dog in the wire crate when you arrived on scene?
Yes, sir.
Would you recognize that photo if I showed it to you?
Yes.
Your Honor, people would like to introduce People's Exhibit 1. A picture of that taken by Officer of the dog on March 1st. Counsel. Officer Jablonski, what is that a photo of?
That's a picture of the dog known as Hoghead Cheese in a wire crate on the front porch of 12012.
And is
I'm
that?
sorry, 12.
And then is that in the, was that located in the city of Lansing, Ingham County, state of Michigan? Okay, and does that picture to appear to accurately describe or accurately show the dog as it was on the date that you got there? Permission to publish to the jury?
For the record, People's One is admitted, and yes.
so let's back up a little bit from March 3rd. Was there ever a time before March 3rd where you had interactions with the defendant?
Yes.
Could you describe the first time, or how many times has your office been called out to the defendant's home?
I could find on record 17 times we've had complaints at 1202 Parkview.
And what was the nature of those complaints?
10 of them were welfare checks on the animals. 7 of them were dog at large violations, 1 resulting in a dog bite.
And were you personally involved in any of those?
Yes, I have been to 3 of them prior to this.
And can you describe the first time that you, first interaction that you had with the defendant?
Well, the first time I've been to the house, I didn't have interaction with the defendant. That was back in June of 2022. We got a complaint. Someone saw a dog at the house that appeared to be in poor physical condition. Throughout our investigation at that time, Ms. Daniels was out of town for months at a time at that point. So the dog was never at that address and we could never find the dog. So we eventually had to close that out. 2 months post that complaint, our director had from the department had gone to the address on unrelated issue in a professional manner. Ended up seeing that dog, couldn't stand up, couldn't walk, was completely emaciated and ultimately seized. And neglect charges were sent up on that. So I don't know what happened with that. I went out to the house.
So that was the first time?
First time, June of 2022.
And you say that the defendant was not located during that time?
Correct.
You didn't make contact with him at that time. Okay, and all right, so tell us, describe to the jury the next time that you came into contact.
It was February of 2025. We got a complaint of the dogs being outside and tangled within their tethers. And Oscar had been out there 2 days prior for the same complaint. When I arrived, the dogs were ultimately inside of the house at that time. So I did speak with Miss Daniels about it. Like, hey, when your dogs are outside unattended, make sure they have food, water, and shelter. Make sure that you are monitoring them if they're going to be untethered so they're not entangling themselves, wrapping themselves up, or each other.
So let's go back to the first time that you were at the house. Did the dog during that time, did you see food and water on that was available to the dogs at that time?
The June 2022 one?
Yeah, the first.
So I never saw the dog there. That's just what ultimately inspired from that original complaint.
And what about the second complaint?
Second complaint I responded to, the dogs were inside and the complaint was the dogs were outside in the yard tethered and entangled. So I didn't see the dogs at that time. But to my knowledge, she did not have any shelters outside. But at that point, the dogs were inside. So we kind of just educate them if they're going to be outside for some period of time, make sure they have water and shelter provided to them.
And tell us about the third time that you were out there.
November 2025, responded to a complaint of the dog in the wire crates on the front porch for an extended period of time. A partner had already gone out earlier that month as well for the exact same complaint and advised her that the wire crate is not for containment for the dogs. It does not provide them adequate shelter. They're completely exposed to the elements in that wire crate. So that was earlier that month when I went. There was 2 dogs in the wire crate on the front porch.
It was
Believed to be the exact same crate. And that
there were 2 dogs in this crate?
Yeah. Yeah.
Was
it was
one of the dogs this dog?
One was Hoghead Cheese and another one named Valentine. Yeah. And I spoke with Daniels there. She was inside the house. At that time, it was actively raining, so the dogs were getting wet in the wire crate. I told her, hey, we're out here to do the exact same thing. Advise you can't use this wire crate to keep them outside. I got an eye roll back at that actually from her. And told her that they can't be outside, especially when it's actively raining outside.
She had admitted to me that they had been out since 5 in the morning that day. I arrived about 2:45 that day, is to say approximately 10 hours. She admits that they were in the wire crate on the front porch that day in November. She did end up bringing them inside. I did give her information to come obtain free dog houses from the shelter, which I did witness her at the shelter obtaining a couple dog houses from us.
Okay, so let's first start. When you said you saw 2 dogs in this particular crate, did they have enough room to move around?
For 2 dogs in that crate, based on their size, they did not have enough room to move around.
Okay. And you said it was raining on both of the dogs at this time? And the defendant admitted at that time that they've been out there for how long?
Approximately 10 hours.
And you said at that time you provided her with some information to come get adequate shelter for us.
Yes.
And you said that she actually did come
Yeah,
get.
I saw her.
What type of shelter did she come?
They're like dog igloo houses, and then when we normally provide a dog house, we provide a vanilla straw for them as well.
And is with your training and experience, is that igloo, what type of temperature would you normally keep a dog in that particular type of shelter?
So the igloo for warm months is just not appropriate to keep them hot. So the law states you have to keep a dog in an adequate state of health. Part of that is providing shelter, but also knowing what will help them maintain their heat when it's cold out. So adding insulation only such as straw, because that's like a water wicking, versus blankets that are gonna freeze and stuff when you're in the cold months. In the summer months, you need to provide them a bunch of shade. If you're just giving them a dog igloo house in a field full of just straight sun, they're gonna bake. So you need some other type of shade in there to keep their dog house cool, keep them cool, maybe breeze and stuff. So in this particular time, November, the last time, they would definitely need a dog house with insulation in it too. Something that is small enough where they can get in and maintain their heat and not too big for them, but it's just a big open space.
And you said you provided straw to.
We should have.
So do you
I
know-
wasn't the one physically giving her the dog houses, it would have been staff.
And when is the next time that you, after the, when's the next time?
It would have been for this case.
So let's go through facts of this particular case. So explain it to me again, how you came to be involved in this investigation.
So the shelter received a complaint of a dog being kept in a wire crate for extended periods of time.
You remember the name of the individual who made that complaint?
Mr. Navarro. Can't remember his name.
If I showed you a copy of your report, would that refresh your record? Your Honor.
Vasquez, Mr. Vasquez.
Okay, so tell us again what how you came to be involved.
Yeah, so we received a complaint from him. The complaint either was after hours or when officer couldn't respond. So by the time we were able to respond, it was 2 days later, on the 3rd. So we spoke with him over the phone to get a statement from him. He said on the 1st, he had witnessed the dog out in the wire crate from.
Objection, Your Honor, hearsay.
Objection is hearsay.
Not Mr. Truman, Master, effective listening. I'm gonna ask her what she does.
Objection is overruled.
You can go ahead.
Continue with it.
Tell us.
This is just the statement we received from him. The dog was in the crate from like 9:30 in the morning till at least 10 p.m. when the individual went to bed, Mr. Vasquez. He did see the dog in the 2nd in the afternoon, and he doesn't know how long the dog was in the crate at that time. And then he was
Let me stop you there. Did he give you a temperature of what when the dogs were out there during that time? you described the temperature was like that day?
The temperature on the day that we went out, or like when he originally
When
called?
you made the original,
I don't remember the temperature then, but the date that we went out.
if you saw it in your report, with that refresh your recollection.
Sure. It's about second to last. one. 26-degree weather. Or sorry, 23. Wow, can't read.
So when Mr. Vasquez made his report, he said he saw the dogs outside. How long?
All day, approximately 9:30 in the morning, so at least he went to bed at 10 o'clock at night.
And you said it was, he reported 23 degree weather. Okay. All right. So what did he say next?
We talked about in a second, he didn't see the dog in the morning in the crate, saw the dog in the crate in the afternoon, and doesn't know how long it had been in there at that point. And then wasn't sure if the dog was outside when we were responding that morning with the 3rd.
Your Honor, I'm gonna remove my objection for hearsay. This is.
Well, I'll withdraw.
Objection sustained.
So based off of your interaction or your conversation with Mr. Vasquez between the 1st and 2nd, what did you do?
We just spoke with him on the 3rd. We responded out to the address. He was just telling us what he had seen the days prior when we spoke to him on the 3rd. And we responded out to that address.
Tell the members of the jury or describe for the jury what you saw when you arrived.
So when we got out there, Hoghead Cheese, the dog that you saw in that photograph, was in the same wire crates that you saw in the photograph on the front porch. It was November, it was March, it was cold, it was 25 degrees, the patrol vehicle said, it was actively snowing. And Hoghead Cheese was physically shivering.
And how long were you out there originally when you came on the 3rd?
When we came on the 3rd, we got there about 9 in the morning. Try to make contact with anyone at the house by knocking on the doors. Try to contact Ms. Daniels over the telephone, didn't have any contact. We stayed on scene for 45 minutes. Because at this point, I was starting to type a search warrant to remove the dog. So that's why we stayed on scene for 45 minutes.
Why did you do that?
I couldn't leave a dog just shivering in the cold without getting contact with anybody to change the situation, to get a hold of Daniels. Hey, get home right away, put him inside. Hey, is any of your children home? Can they get him inside? Just to get him out of this cold weather. And I couldn't just leave him shivering there. So we started talking.
Did you have concerns about the health, the dog's health at that time?
Yeah, when you start actively shivering, that is like your body's natural reaction to protect itself and protect its organs, just like any human. You start shivering when you're cold, and then if it gets worse, you don't address or anything like that, it can slowly go into like organ failure, and it can go into death if it really just hypothermia. It's the same thing for a dog. So
can you just so I'm sorry to interrupt. Can you just describe? So are you familiar with this particular breed?
yeah, he's like a triple mix or a Pussy Canario mix. They're very short haired. With the short hair, they're not good with being outdoor old dogs.
Objection, Your Honor. This appears to be expert-based testimony. I'm not sure she qualifies as an expert.
She want to respond.
I don't believe she's just given her opinion, hopefully based off of her training experience about dogs, and she's had more than 6 years experience.
Can you speak up? Your voice is so loud.
The witness has had more than 6 years of training and experience dealing with cruelty and dealing with dogs. So she's just given her opinion about the nature of this particular dog.
I don't recall you asking her a question about her opinion. She's been given a narrative the whole time. She can only answer your questions. That should have been your objection. So no, that's stricken. She's got to answer your questions. You asked her, was she familiar? That's yes or no.
Are you familiar? you're familiar with this particular breed of dogs?
Yes.
So based off your familiarity and your training experience, tell me what you believe that dog, what the conditions were, how did they affect that dog?
That particular dog is a short-haired dog. They don't typically do as well.
Objection, Your Honor, lack of personal knowledge.
Do you have personal knowledge about this testimony?
Yeah,
That you're
I
giving?
know that short-haired dogs do not do well.
That's just in general.
Yeah.
And that's based off your training and experience.
Yes, ma'am.
Objections overruled. You can continue.
So tell us about the short-haired dogs.
Short-haired dogs typically don't do as well in colder temperatures versus a husky or a Pyrenees or something that has a long hair.
And so again, you arrived on scene on the 3rd. You made contact, or you stayed there for 45 minutes. You typed up the search warrant because of what you saw there. What happened after that?
We ended up having to leave the scene for a priority call. So we left and addressed a different complaint that was happening. And then we came back at approximately 11.
And describe to the jury what you saw at 11 o'clock.
Hoghead cheese was still out in the wire crates. And we came back at about 11 a.m.
And was there another dog that was on the property at this time?
Yep, the dog Malachi was in the backyard tethered. He did have a dog house, but without straw.
And what was the condition or demeanor of Malachi at this time?
Malachi was not happy that we were there, so he was active, bright, alert, responsive.
And but this was the same. You said it was. Did you say it was 25 degrees?
For the patrol vehicle, yes.
And was Malachi outside when you originally arrived at 8 o'clock? Or
9, yes.
Okay, he was tethered in the backyard. So described again to the jury the second time that you came out. What was your interaction with the defendant at that time?
So as soon as we arrived back at the house, we tried Miss Daniels on the phone again and finally got a hold of her. She said that she was inside, so I told her that we addressed, Hoghead cheese being outside in the winter crate.
How did you get a hold of her? Did you knock on the door?
No, we just called her when we arrived back at the house.
The second time, you just called her. And what did, once you got a hold of her, she over the telephone, what was the conversation?
She explained to me that Hoghead cheese.
Objection, Your Honor, hearsay.
You want to respond to the hearsay objection?
From a statement of the party.
Objection overruled.
So yeah, you can tell us what she said.
Okay. Miss Daniels told me that Hoghead cheese had broken his tether, so that's why he was in the wire crate. Said that her child was going to give him a bath in the next 10 to 15 minutes because he had gotten skunked, sprayed by a skunk, and that's why that was her reasoning and why he was on the
When you were there twice that day, right? Did you smell any skunk smell from this dog or the other dog?
No, I got within close proximity to knock on the front door, which Hoghead cheese is right next to, and not smell.
Do you know, as your training experience as an animal control officer, do you know the smell of skunk smell?
Yes, sir, very well.
They smell at all like skunk. Okay. So after you got the call, after she picked up the call and she gave you this story, what happened next?
She did come outside. I exited my vehicle and tried to speak with her. She would not converse with us at all. She did bring the dog back inside and then she left in her vehicle.
And what did you do after that?
Then she came back in her vehicle, tried to talk with her again, and I told her that we have a tether on board if she wanted one, because that was the reason that he was in the wire crate, and she denied wanting the tether, and she grabbed more children from the house and left again. So we left the scene because the dog was inside now.
Did you have any other interaction with the defendant after you left, after she left the second time? And did that conclude your investigation of this incident? So describe to, and were charges sent over to the prosecutor's office based on the investigation? So describe to the members of the jury why you believe it was necessary to file charges.
Based on the multiple times we've been out there, have spoken with the owner on what is necessary to keep the dog in adequate state of health, with shelter, with food, with water, and providing some of those supplies to make her compliant and keep the dog healthy. She has still neglected to do that and still kept putting the dog in the wider crate for extended periods of time. And he was actively shivering, and I would have left him. She didn't come home for however long, like it could have resulted really badly for the dog.
We're talking about both dogs.
Specifically Hoghead Cheese, Malachi did have access to a shelter that he could get into. I do believe that he needed a lot more straw in his shelter to help him maintain some heat.
Was there any straw in Malachi's shelter?
I think there was like a thin layer on the bottom.
Was, based off your training and experience, was the straw that you saw sufficient in order to keep this dog warm and out of the elements, in order not to suffer from a cold?
Absolutely not. We always recommend people to fluff up the straw and stuff it pretty much full. The dog will burrow in there because it's going to be a windbreak. It's going to help them maintain their heat. It's going to keep them dry when it's fully stuffed. If it's just a layer on the ground, it's really not doing anything.
You said, but cheese didn't have any straw.
Correct.
So,
Or any windbreak.
so, and I think I interrupted you. Did you have any other thing that you want to say about why you believe that charges were necessary?
Just because it's just a constant thing. I'm getting called out there for the same issue. Miss Daniels not taking our advice, not taking our education, not understanding what it means to shelter a dog, provide it necessary tethering, water, food, stuff like that. And no matter how many times we've gone out there, supplies we've offered her, she's just choosing to not comply.
For this time that you went out there last on March 3rd, was there water available to Hoghead Cheese?
No.
Was there food, any food anywhere around?
No.
How about Malachi backup?
Yeah.
And did that conclude your investigation?
Yes.
Okay. No further questions for this witness.
Cross-examination.
Officer, it was previously Jablonski, it is now.
It's still Jablonski for.
Okay,
Josh.
got it,
Yeah,
got it.
thanks.
Okay. I just want to talk to you a little bit about March 3rd, okay? When you arrived on March 3rd, you didn't find dogs to be in poor health, did you?
Their body weight was adequate.
They showed no signs of starvation then, no ribs showing.
Correct.
They weren't suffering from any noticeable injuries.
None that I saw.
There weren't any, they weren't showing any signs of obvious illness, foaming at the mouth or lethargy, anything like that.
They were active, bright, alert, responsive.
You also didn't do any further investigation into their health, did you?
No.
So no veterinarian was called to the scene to look at the dogs or evaluate them?
Nope.
Those dogs have consistently been found to be in good health, haven't they?
Malachi and Hoghead Cheese, yet there's have been no issues with their body condition.
out of the various times that you mentioned responding to Ms. Daniels' property, how many times were those dogs found to be in good health?
They've always, to my knowledge, always been like an adequate physical condition, like they're being fed properly.
And also exercise properly, they're in adequate physical condition.
Objection. Call for speculation.
Do you want to respond to the speculation objection?
Your Honor, I would just say that it's actually based on her personal knowledge, so they didn't appear to be overweight. Essentially is my question.
Objections overruled.
They were not.
Relative to investigation, did you investigate the inside of Ms. Daniels' home to see if any supplies were kept there in terms of dog food, those kinds of things?
Just in relation to the.
Did you knock on her neighbor's doors?
No.
So you didn't collect any kind of witness statements from her neighbors about what they had perceived between March 1st and March 3rd?
Just the original reporting party.
Okay. Now, you mentioned that the photograph that was published to the jury, that you took that photograph on March 3rd, is that correct? Does that picture show any type of timestamp in your phone?
Not recall.
Would you like to look, if you were to review it with that kind of re-jog your memory?
Are you trying to, you want me to give you like an actual time that I took that photograph?
Well, I'm wondering if the picture itself is timestamped.
Oh, no, I can look for you. Yeah, sorry. No, it isn't.
You also mentioned at some point during your testimony that you had previously seen the two dogs in the one crate. Is that true? Okay. But we don't have a picture of that today. The initial complaint in this case was made on March 1st.
Yes.
And you received that complaint on March 1st, correct? Your office?
The office.
But you didn't respond until March 3rd.
Correct.
Wouldn't that tend to indicate that there wasn't an imminent threat to these animals?
Objection.
What's the objection?
Call for speculation.
Well, I don't know that it calls for speculation because she's the one making the determination as to whether or not there's an imminent threat. It's part of her duty as of an officer. So it's actually her job to do that. The objection is overruled. You can answer the question.
I can't testify to like what exactly was going on that day, you know, what other higher priorities we could have had that day as well. To make that go like further down the list if we have like aggressive dogs or anything like that. So it is a priority, stands that there's higher priorities and we respond to that one over this one.
Okay, understood. You also mentioned that Ms. Daniels has never complied with any of your advice or recommendations that you've ever provided. Is that correct?
I wouldn't say never comply, but she chooses to not always comply.
But the dog house that you mentioned seeing in the backyard, that is from animal control, correct?
Yes.
Okay. And the straw that would have been there, that's also from animal control, correct?
I would presume that she got her own.
Okay. The law permits you to apply for a warrant to seize animals under certain conditions, doesn't it?
Yes.
And what are those conditions?
If there's like immediate threat to the animal, if basically any crimes are being committed to that animal, no food, water, or shelter, unsanitary conditions, not providing veterinary care, and anything that can apply under those.
Okay. And the standard for that evidence is plainly evident, has to be plainly evident that these things are happening or that there's an imminent threat to the animal. Is that correct? Now, you completed an affidavit for a search warrant in this case, didn't you?
know if it was ever completed, but we were checking one out. I can't recall if it ever happened.
If I were to show you the report from that day, would that help to jog your memory?
Maybe it's from the affidavit.
I can do that too.
Okay.
Your Honor, please let the record reflect that I am showing opposing counsel the affidavit for search warrant.
So noted. What was your question?
My question is whether or not you actually submitted the affidavit for search warrant on March 3rd, 2025.
Yeah, looks like we submitted the search warrant to assistant prosecuting attorney for the review.
Okay. But you didn't take the animals with you that day, did you?
We never had it signed by a judge.
Okay, so you submitted it with all of the evidence that you had from the scene. It was signed by an Ingham County prosecutor, but the judge didn't sign.
It's because when we went back and she brought the dog inside, we didn't go through with the search warrant at that time. So in between the time writing the search warrant affidavit, sending it off, we had another priority call to go to, coming back, finally making contact with Daniel. She brought the dog inside. That was the main issue, is that the dog was outside shivering, didn't have adequate shelter. So there was no need to do the search warrant.
Okay, so once the dog was returned to my client's care, you had no further concerns?
Once the dog was brought inside of the house.
In my client's care. Thank you. No further questions.
Redirect.
Yes, just briefly. So you on cross-examination, defense counsel asked you a question about whether or not the dog had sustained injuries on March 3rd. Does being outside in 23-degree weather, does that have outward injuries?
You can get.
Objection, Your Honor. Again, she's not a veterinarian. She is an animal control officer.
I'm asking her to give her opinion about what she understands about how cold weather affects the dogs.
So you're asking in general, in 23-degree weather, does that have outward injury?
For that
But when we're talking about how many different breeds of dogs, way too general. Objection sustained.
This particular dog, this Presso Canario. Do you know if it typically an outside dog or inside dog?
They can be either, as long as they are given the proper supplies that are adequate for them to stay in a good state.
But you testified earlier, I think it has a short coat.
Correct.
Right. Is that coat adequate to keep a dog from sustaining injuries in 23 years?
Objection, Your Honor. I'm not sure that she has the training to be able to answer the question.
I still think it's general, like, because what kind of injury are we talking about? You talking about a cold-related injury? Okay. I don't know if that's within the realm of her experience, to be honest. I would have to defer to Officer Jablonski.
I do have a response to that with experience, yes.
Okay, I'll allow Objections overruled. I'll allow your response.
What I can say is with, dogs being kept outside in its cold temperatures, you can start to develop frostbite.
Uh, Did you see, did you observe any frostbite on this dog? You did not. And um, animal control, if she needed additional supplies or help, care, would your office offer that?
100%.
So she could have called at any time to get another igloo for the dog that was on the front porch. She could have came and got straw at any time to insulate the dog houses.
Yes.
Did she do that?
Not to my knowledge.
No further questions.
Any questions from the jury? For this witness, before she leaves? So what happens is the witness leaves, it's time to deliberate, and then all of a sudden you have questions for this witness, so just want to make sure. Okay, thank you, Officer Javon. They need to take a break, we'll get the check. Okay, we're gonna give you a brief recess so you can stretch, and I think you need to go down to the Treasury Department. You're not free to deliberate or discuss the matter, nor are you to speak to anyone, including the attorneys, even if it doesn't have anything to do with this case. All right. Two-minute recess, I guess. Get some minutes, get water. Run to the restroom downstairs, whatever you gotta do. Call your next witness.
One of the people are called Gustavo Perez. Oh, Gustavo Vasquez.
Hey, Gustavo Vasquez, can you hear us?
Yes, I can. Hello.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay. State your name, your first and last, and then spell both.
My name is Gustavo Andres Vasquez Montoya.
Got to spell it.
Right.
Just your first and last name.
Yes. So my first name will be Gustavo, and my last name is compounded will be Vasquec, followed by Montoya.
Thank you, Your Honor. Gustavo, or Mr. Vasquez, you're appearing remotely. So that's typically not ordinary in cases. So can you tell us where you're zooming in from?
I am zooming in from Colombia, the city of Medellin.
Can you, and I'm gonna direct your attention to March 1st of 2025. Do you remember that day?
Yes, sir.
Where were you located on that day?
We were in an Airbnb in Lansing.
And why were you in the Airbnb in Lansing?
Visiting family.
What were you doing? And hopefully it was a good experience, other than the issue that brings you to court.
Yes.
Can you tell us when you were there, did you contact Ingham County Animal Control?
I did.
I would want you to tell the members of the jury what was the reason that you contacted Ingham County Animal Control?
Yes. So when we arrived to the Airbnb, it was a very cold, very chilly day. I would wager it will be in the 30s. As we went in, we noticed that there was a barking dog outside. It was right across the street, so I had a direct view, line of sight to the dog. The dog was on a cage outside. So because it was barking and it was so cold, we got worried. As time went on, we continued to notice that the dog was still out there, just barking, and it was quite frankly heartbreaking. So the family discussed internally, and we decided to make a report at the very least, so that somebody could come by and maybe do something for the animal.
Okay, I'm gonna show you a picture that was previously identified as the People's Exhibit 1. Could you tell me if this was the dog and that you saw in the cage? Where would I show you?
It's gotta be virtual because he's your virtual witness.
So I would have to log in?
Share your screen. Otherwise he can't see it.
Oh, let's.
I'm in the meeting. Are you able to see that? See that picture?
Yeah, I do.
Is this the dog that you seen on March 1st?
I believe so, yes. And that is exactly the house that is the cage that we saw that day, for sure.
What's the matter? Oh, what's the matter?
I'm just.
I can remove it if you're done.
Yes.
Okay.
Okay. So let's go back to the beginning, when you very first heard the dog start barking. Do you remember what time that is?
By my estimation, it will be early in the morning, 10 a.m. roughly.
And your Airbnb was located across the street.
Correct.
And you heard this dog barking about 10 in the morning.
Correct.
Right? And then Officer Jablonski stated that the temperature outside was 23 degrees. Would you have any reason to dispute that?
No, that sounds correct.
Okay, so the barking started at 10 a.m., approximately around that time. How long did this barking go on?
The entire day. We stayed there the entire day, and when we went to bed approximately 10 p.m., the dog was still there. We checked on the window the entire day because it just kept barking, and we were all heartbroken because it was really sad. It was so cold outside, and even at night it was still there. So we just didn't know what to do other than making the report.
So it was barking all day, all night. Was it in this cage? Was it in that same cage every time you heard it?
Yes.
And on March 1st, were you home pretty much throughout that entire day?
Yes.
Okay. And then what about March 2nd? Did you hear any barking at that time?
So on March 2nd, when we woke up, we couldn't see the dog outside anymore, but we could still hear it barking. It seemed that at that time they had moved the dog to the back, but we could still hear it barking. So we tried to look around. We didn't have a good line of sight, but we could still hear it.
And was it approximately the same temperature that day?
Yeah, I will say so. It was still freezing.
Okay. And how long on March 2nd did you hear the barking of the dog?
Yes, so we left the house around 11 to noon approximately. So it would be that period of maybe 10 to noon in the morning before we left.
And then after you got back, did you hear barking then?
I think so, yes, I believe so. It's been a while, but I do believe so.
And based on what you observed on both March 1st and March 2nd, what type of concerns did you have about the dog?
I thought the dog was gonna die, quite honestly. It was so cold outside, it was the entire day. And we thought that it was gonna die, or at least be very sick. It was so cold.
And when did you, so you made a report to Ingham County Animal Control, correct?
Correct.
Did they speak with you about that, your report?
I received a call after, basically confirming that I had made the report and for further details. So I shared an explanation of what we were seeing at the time, I believe.
Yeah, and you stated to that officer just what you observed, your testimony here today, right?
Correct.
And when did you leave the Airbnb?
I think it was later on March 2nd at that night. We spent, I don't remember exactly, we spent 2 to 3 days in that place. I don't remember exactly, but I feel like it was the next night.
And now you're back in Colombia. Hopefully the weather is a little bit better then.
Yeah, it is.
I have no further questions for this, but it's good.
Mr. Vasquez? I know it's a little weird, you can't see me.
Hello.
Hi. When you awoke on March 2nd of 2025, the dog wasn't in the crate, was she?
No, it was not on the crate.
Okay, but you said you still heard barking.
Correct.
Isn't it possible that that barking could have come from another dog, perhaps even a dog that wasn't owned by Miss Daniels?
So it was definitely coming from that house. As I mentioned, at that morning, it was not in the crate, so it seems that it was moved to the back of the house. We asked this ourselves, could it be another dog? But it was unlikely, at least it was from the same house. It seems that it just was moved in the back out of sight because the crate was right in the porch, right?
Thank you so much for your extensive testimony. I'm going to ask you to curtail your answers for me to yes and no responses.
Okay.
Thank you. So you said that you heard the barking coming from that direction. Did you go in and you didn't investigate though, did you?
We did. We didn't went into the property through the sidewalk. We looked to see if we can see the dog. It was unclear.
But you never visibly saw that dog, did you? The one that was barking.
I can't say that it was the same dog exactly. I couldn't see it clearly.
Exactly. On March 3rd, when animal control came to your house, you hadn't seen the dog in the crate that day either, had you?
On March 3rd?
Wait, there's an objection. What's the objection?
No, lack foundation. I don't believe he stated that they came to his house on March 3rd. I think they contacted him on March 3rd. I think they called. Is what Officer Jablonski's testimony.
Okay. I can rephrase.
Thank you.
So, Mr. Vasquez, when animal control contacted you on March 3rd, you hadn't seen the dog in the crate that day, had you?
So we saw the dog on the crate on March 1st. That's it, the first day.
On March 3rd,
First
Mr.
day.
Vasquez, on March 3rd, when animal control reached out to you, you hadn't seen the dog in the crate that day. Isn't that correct?
It was a different day.
On March 3rd.
It's a yes or no question. And I think if you don't answer it properly, it could cause confusion for the jury. So you need to answer yes or no, or if it doesn't apply, that's different. But this is a
Yeah.
yes or no question.
I apologize. I'm a little bit confused by the dates. So I think the answer is no. It was a different day.
Okay, thank you. On March 1st, you said that you first saw the dog in the crate around 9:30 when you woke up. Isn't that correct?
It's when we. So yes. So yeah. The next day, yes. When we woke up, we didn't see the dog. We heard it. The first day we arrived. So.
Oh, I'll clarify. So I'm talking about March 1st. March 1st, I do believe you testified, is the date that you made the report to animal control.
Yes.
Okay. And on that day, you said that you woke up around 9:30 and that you saw the dog in the crate at that time.
No, that day we arrived. So it was the next day that we woke up. So that day I saw the dog, yes. Just confused with the wording. I'm sorry. I don't want to be obtuse.
I do believe you just mentioned to the prosecution that on March 1st, you made a report to animal control.
Yes.
Okay. And on that morning, did you view the dog in the crate?
Yes.
Okay, thank you. And then that evening around 10 p.m., you saw the dog at that time?
Yeah, still in the crate the entire day.
Okay.
Yes.
And you didn't watch the dog the whole day though, did you?
Pretty much, honestly, it was not the entire day, but almost. We kept looking at the window throughout the day. So actually, yes.
Okay, so you came to visit your family in Lansing to spend a day looking out your window at a dog?
It was heartbreaking. So I kept looking through the window every 20 minutes, honestly. We talked.
Did you make multiple calls to animal control that day?
I think I did the report, tried to reach out. I don't recall multiple calls. It's been a while.
Okay. Can you recall anything else that you may have done that day?
Yes. So we had food. I played with the kids. We chatted. Family watched the movie. I worked a little bit in the computer. As I said, I just kept looking through the window.
Okay. So you also said that you thought that dog was going to die.
It was my concern, yes.
Okay, and you had that concern on March 1st when you called animal control?
Yes.
And you mentioned to them that you were afraid that the dog was going to die.
I'm not sure if I explicitly state that.
Okay. So then you must have been surprised, though, that they didn't respond until March 3rd.
I don't know how law enforcement operate necessarily, so.
Okay, so for a dog that you were worried was dying, you weren't concerned that they waited 2 days to respond to an incident you had reported to them as being dire?
I would prefer a faster response, definitely.
Were you surprised, I think is my question.
No, because I don't know how this works, so it's hard to build surprise. I don't know.
Okay, well, you never saw the dog appear to show any signs of being in poor health, did you?
I mean, it's hard to say. I would say that barking all day.
It's simply a yes or no, sir. It's either you saw the dog be in poor health or you didn't.
He looks desperate to me, yes, just a sign of poor health to me in the cold. I will say yes.
Okay,
but
so
it's-
you saw that dog with obvious injuries?
No,
You saw that dog looking malnourished with bones showing, ribs, cage showing?
no, I didn't get that close.
You saw it with matted fur, appearing to maybe foam at the mouth or drool at the mouth?
No, didn't get that close.
You never saw it be malnourished or lethargic, laying down, not moving a lot, not barking too much?
Hard to say, but no, he was barking a lot.
You never approached that dog, did you?
I mean, not physically. We were so close anyways, I could directly see it. It went.
Oh, so it wasn't so hard to tell whether or not the dog was in poor health?
I mean, it was. It was far away enough that I couldn't tell if it was wounded or injured or malnourished necessarily, but I could clearly see it.
Okay, so you don't have any specific articulable examples of that dog being in poor condition, physical poor condition?
It's hard to say, yes.
It's hard to say yes, is what you're saying?
No, excuse me.
It's
Yeah.
yes or no. We're not asking you what's difficult to say. Is that a yes or is it a no? Saying it's hard to say, yes is a confusing answer. I don't know what you're talking about.
Yeah, I'm sorry. So I don't have that evidence, yes.
We didn't ask you, did you have evidence? I think, we'll repeat your question.
My question is whether or not he ever viewed that dog to be in poor health.
Yeah, that's a yes or a no.
No, I don't know.
Thank you, Mr. Vasquez.
Any questions from the jury? Redirect. Still no questions from the jury? You can write it down, sir. What time did you make the call to animal control, sir?
So I cannot recall the exact time. I would say it was probably early in the afternoon, maybe around noon. Because after a while the whole family got very worried that it was too cold for that dog to be outside for even 2 hours.
Any cross or redirect based on that question? Okay, thank you, Mr. Vasquez Montoya, you may be excused.
Thank you, Mr. Montoya.
Thank you. Have a good one.
You can call the next witness.
The people restaurant.
Can you give the snack card for the jury?
Yes.
Okay, I'm going to release you so that you can have a brief break while I address some things privately with counsel, and then we'll have the snack cart brought down for you. You're still not free to deliberate. And
Not gonna pass out.
we'll see if we can smuggle some cart snacks for the attorneys. when we're done. You know, I'm saying. I'm like, it's hard to get snacks. No, for real. Very much. Um, No, they forced it. Uh-oh, we exceeded the time limit. Okay, you can be seated. Oh, yeah, no objection to me doing the composites before you do your closings. Okay, last set of instructions, and then you'll get the closing arguments. Members of the jury, the evidence and the arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way, decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that the defendant did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence in each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching and listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether this disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime occurred on or about March 1st, I think that's supposed to say March 3rd, through March 3rd, 2025, within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions along with you and your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried like in a business-like manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones and other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is the duty or your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and your reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinion and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your own honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judge, the lawyers, or the court officers, or other people involved in the case. As you discuss the case, you must not let anyone, including me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, again, you will take your notes and a full copy of the instructions. If you want to look at any of the reference documents or exhibits, I think there was only one exhibit admitted, correct?
Yes.
Okay, you can just ask for them. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss this case, you should think about all of my instructions together as the law that you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you can consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking the same example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she did, what she said, and how she did it, or by any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness who, it's not a police officer, but we did hear witnesses from Ingham County Animal Control Officer. The testimony is to be judged with the same standards you use to evaluate the testimony of any other witness. Ingham County Animal Control Officer Spencer Bennett is a missing witness whose appearance was the responsibility of the prosecution. You may infer that the witness's testimony would have been unfavorable to the prosecution's case. Again, the elements of the crime: animal abandoned and cruelty. The defendant is charged with animal abandoned and cruelty. I think as charges it 1 to 2 animals. It's charged animals abandoned cruelty, 2 or 3 animals is how it's charged. Okay, to prove this, the defendant, the prosecution that is, has to prove beyond a reasonable doubt first that the defendant owned, possessed, or had custody of a dog or dogs under her care. Second, that the defendant failed to provide the dog or dogs with adequate care means providing enough water, food, exercise, and providing sufficient shelter, sanitary conditions, and veterinary care to keep an animal in a state of good health. Or that the defendant was negligent in allowing the dog or dogs, including aged, diseased, maimed, or disabled animals, to suffer unnecessary neglect, torture, or pain. Neglect means failing to sufficiently and properly care for an animal to a degree that the animal's health is jeopardized. Or that the defendant tethered the dog with a rope, chain, or similar device that was less than 3 times the length of the dog from nose to the base of its tail. And that concludes the jury instructions. You can do your closing argument.
Your Honor.
So this is a time during the trial where I come back before you and tell you what I believe that the testimony that you heard, I believe that you should conclude based off of that testimony. So, you know, I'm also going to ask you to find the guilty of the crime as charged. So, just to recap what you heard today. You heard directly from Mr. Vasquez over Zoom that he witnessed, he was here in town visiting family at an Airbnb. He doesn't know the defendant. He had no reason to make up a story on the defendant. He saw this dog in this cage. He said it was 23-degree weather outside, and that dog continuously barked for over 10 hours. Why would he make up that story? Based off of what he saw, he was so concerned that he called animal control because he believed that the dog was in jeopardy of losing his life. He called an animal control, and he heard the dog barking that day on March 1st. He heard a dog in their property barking again on March 2nd. It was just as cold that day. And when animal control arrived on March 3rd, saw the same dog, same cage, just as cold, shivering, she said. I'm going to ask you to find this is not adequate shelter for degree weather. Not adequate shelter. They didn't say they saw this dog get any water, any food. Didn't hear any testimony that any food was around. Didn't hear any testimony that clean water was around. Or you heard testimony that this dog stayed outside inclement weather over 10 hours at the very least. When Officer Jablonski from Animal Control, Ingham County Animal Control, attempted to contact the defendant on that 9 o'clock in the morning, knocked on the door. Defendant didn't answer. She heard the dog. She could have heard the dog barking, just like the neighbor across the street heard the dog barking. She could have heard that dog barking. She could have came out at any time and took the dog back into the house, got a proper shelter, gave it proper food. We wouldn't be here. That was the defendant's decision. Animal Control knocked on the door. They stayed at their house for 45 minutes. No one came out. They had to take another call. They came back to the house. About an hour later, dog was still in the cage. 23-degree weather. Knocked on the door for another 20 minutes. Defendant finally answered the phone. And she said she was there all day. Just didn't come to the door. That's cruelty. 23-degree weather. This cage. That's neglect. So, based off the testimony that you heard today, just two witnesses that were more concerned about this dog than the defendant was. I'm gonna ask you to find her guilty of both charges. One, because you heard direct testimony of the state of this dog on March 1st, 2nd, and 3rd. And then you also heard Officer Jablonski state when she got there on March 3rd, Malachi was in the back, tethered in an igloo that the defendant did receive from animal control. That's a igloo, that's a shelter that animal control provides. But she told you that just that igloo and that amount of straw was not proper shelter for Malachi, the dog in the back, in 23-degree weather. He told you that. She got that shelter, the defendant got that shelter, that igloo shelter from animal control. She knows the extent to which the dog is properly sheltered by them. And because you heard that testimony, each of those credible witnesses, I'm going to ask you to find her guilty. You got direct testimony from the people who observed it that on March 1st, March 2nd, or March 3rd, and any other element that you didn't hear direct testimony on. There's sufficient additional circumstantial evidence for you to reasonably conclude that those elements have been met. Because the defendant's choices on March 1st, 2nd, and 3rd, I'm going to ask you to find her guilty as charged with the crime of animal cruelty.
Members of the jury,
The people allege that my client failed to provide her pets with adequate care. However, they must prove Ms. Daniels' guilt beyond a reasonable doubt. And they must do so clearly that no rational person could doubt it based on the evidence. So I ask you, do exactly that. Evaluate the evidence. Okay, let's do that together. Okay? Number one, let's look at the health of the animal. Both witnesses today testified that they had no evidence that these animals were ever in poor condition or poor health. Okay. We heard firsthand from Officer Joblonsky, okay, who has, as she mentioned, extensive experience investigating crimes of this nature, okay, this nature. In her own words, she stated that the dogs were consistently, not just that day, but consistently found to be in good health, okay? Directly from her, we hear that on March 3rd, when they finally arrived to investigate, okay, that both animals were found to be with adequate weight. They were active, bright, alert, responsive. These are not terms or characteristics that would tend to indicate that these animals are in poor condition. The law requires that they be in good condition. That is what happened. They were in good condition. We even heard from Mr. Vasquez, okay, who rented an Airbnb across the street. It wasn't 100% clear which days he viewed the animal being in the crate and not in the crate, but it is clear that he made the call to animal control on March 1st, okay? And on that day, he states that he did not get close enough to the animals to determine whether or not they were showing signs of poor health. But he was also very concerned that they were going to die. Unfounded, simply unfounded. And if he felt that way, doesn't it seem appropriate that that's exactly what he would have communicated to animal control so they could properly evaluate and respond to the urgency of his call? But he couldn't recall that that's what he told them. Let's look at the fact that he called them on March 1st, but animal control did not respond until March 3rd. You would think, based on Officer Joblonsky's testimony of having responded to that address multiple times, and her saying that she had some concerns about Miss Daniels' ability to take care of these animals, that they would have responded more quickly. Or again, is she considering how unfounded some of this is based on the fact that she can see in the records right in front of her from her own colleagues that these dogs consistently been found to be in good condition? Let's look at the warrant. Okay, the fact that in situations like this, okay, Officer Joblonsky told us that where it is plainly evident that the animals are facing an imminent danger, okay, including death, as Mr. Vasquez mentions, that they can appeal to a judge, okay, to have those animals seized. They can apply using an affidavit or a search warrant. However, on that day, that search warrant was not signed. And it's not because Miss Daniels simply arrived at her front door and responded, and so she didn't submit the warrant. She submitted the warrant. It was signed by an Ingham County prosecutor. It was submitted to a magistrate. It was not signed. Finally, let's look at how thorough the investigation was. Okay. Officer Joblonsky, again, she recognized that she's not a veterinarian. That's not her formal training, but she is an investigator with 6 years of experience. However, she did not canvass the area. She did not knock on additional doors in that neighborhood to determine whether or not Mr. Vasquez's statements were truly credible. Right? She did not walk the perimeter to see if maybe something was missing. Maybe those food bowls were out of sight, were immediate sight. We have no videos. She mentions that she found this dog shivering in the cold, but we get a still photograph. We don't get the full effect of the shivering. And it would seem that an investigator with 6 years of experience doing this line of work would know exactly how to prove in a court of law that what she's alleging to happen is actually happening. So again, I don't want to belabor you with the law. You know what the law is. The judge has explained it to you. I would simply ask you to review the evidence. It can be direct, it can be circumstantial, but it has to be some type of evidence. Thank you for your time today.
Anything, brother?
Yeah. Owning a dog, ladies and gentlemen, I don't think it's just a privilege. I think it's a responsibility. And at minimum, pets deserve proper food and shelter from their owners. But they really deserve a little bit, much more than that. They deserve an owner who understands the responsibility and the commitment of pet ownership. And that's what this really boils down to. Whether the Ingham County Animal Control has a lot of different calls that they responded to, and they couldn't get out to this home as quickly as I would have liked, doesn't make this any less of an animal cruelty case. Just doesn't. I would have hoped that they would have got there immediately, but I'm sure they have more than one call at animal control. You heard on the testimony that she was at the home on the 3rd, and she had to go respond to another. Right? So I don't think the fact that they didn't immediately show up would allow the defendant to get off the hook for having a dog in this type of cage, 23-degree weather for hours on end. I don't think that's reasonable. And I don't think it's reasonable for a proper owner of a dog, listen to the dog bark for hours on end, just like the neighbor across the street, and for them to do nothing like that. I just don't think it. I don't think that's reasonable. I don't. So you're going to get a chance to deliberate this case after I sit down. And when you're back there in the deliberation room, I want you to, one, this picture in your mind, 10 hours. You all know how cold 23-degree weather is. And you're thinking, I wonder what's going to happen to the defendant if I find it guilty. You can rest assured and know that we don't have to answer that question today. The judge is going to answer that at a later date. That's just not why we're here today. The only reason, the only thing that we have to determine today is whether or not this is proper shelter, 23-degree weather, and whether you would consider this to be animal cruelty or neglect. That's the only thing that we're here for today. Based off the testimony that you heard, I think you could reasonably find defendant did not provide proper shelter for her, for this dog, or for the dog in the back of the home. And that's why you should find her guilty as charged. Thank you very much.
Okay, ladies and gentlemen of the jury, that concludes the proofs and the arguments. We've also gotten a conclusion of the jury instructions. I'm going to release you now for your purposes of deliberation. You can take your notes with you. My court officer will provide you with a copy of the jury instructions. Again, remember that you do need to first choose a foreperson. If you have a question, that foreperson will write the question down and knock on the door, and he'll retrieve the note from you. Let me swear you in. Do you solemnly swear or affirm that you will, to the utmost of your ability, keep persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or of them orally or otherwise until the time that they are discharged? Thank you. All rise for the jury. Oh, I'm sorry. We gotta release the alternate. There's seven, there's only six of you have to deliberate. One of you were the alternate. I hate to disappoint juror number one, but you're free to go. Thank you for your service. The rest of you are free to deliberate.
I just leave this here.
Oh, yeah, I'll take that. Thank you. Stand by until the time that we get question or verdict. See if I can. And my understanding is that you do have a verdict, is that correct?
That's correct.
Are you the foreperson, sir?
Yes.
Okay, if you can stand and read your verdict.
For the defendant, Tricia Daniels, count one, animal abandoning cruelty of two or more animals. We found guilty of the lesser offense of abandoning or cruelty to one animal.
Did you want the jury polled? Did you want the jury? Okay. Juror number 2, is that your true and accurate verdict?
Yes.
Oh, you all are out of order?
Yeah.
Okay.
She's two.
Okay. Yes, that's why I was asking. Yeah, that's what I was asking. Juror number 2. Is that, okay, juror number 3? Is that your true? Okay, juror number 4, is that your true and accurate verdict?
Yes.
Juror number 5, is that your accurate verdict? Juror number 6, is that your true and accurate verdict?
Yes.
And juror number 7, is that your true and accurate verdict? Thank you. And I want to thank you all for your service. Also, thank you for bearing with us. I know the temperatures and the conditions are not ideal. Our months in this building are numbered, so better days are coming on the horizon. But again, this system doesn't work unless we have people like you who are willing to participate, be attentive, and make the process do what it's supposed to do. So thank you again. It's up to you if you'd like to stay behind and speak to any of the attorneys. Otherwise, you're free to go. All right, jury. Okay. All right, so this matter, there was did I get the verdict form? Any objection to immediate sentencing?
No.
We can make our decision.
Yes, Your Honor. Ms. Trish Daniels, I believe it's forthcoming about wanting to be a good pet owner, and she has taken various recommendations from the animal control team, and she has implemented recommended changes throughout her interactions with animal control. I would ask the court today to take into consideration that she is a stay-at-home mom, not stay-at-home, she works from home, work from home mom of 4 children, in addition to her 2 dogs. I would just simply ask this court for fines and costs.
Works from home, where is she working? She reported she was working at Amazon. You're not at Amazon anymore? She worked from home. At Amazon?
No, oh, I'm sorry, Your Honor, that must have changed.
Okay. That was in October 2025. She reported she worked at Amazon. So you don't work from home, you work outside the home?
I do both, like if Amazon is slow, because I drive Lyft.
Oh, okay, got
So
it.
if they slow, then I will do a work from home job.
Okay, so
I
you have
do
multiple streams of income. Okay, and you still have the animals?
Yeah.
Okay, and I don't know, I think it's very clear to this court, and it should be clear to you now too. The sensitivity people have regarding animals and the care of the animals. We, in our history in this program, have had struggles even impaneling a jury if it has anything to do with animals. We don't have that same issue when we're impaneling it for domestic violence or an assaulted guy. But there's something about how people feel about their pets and how they feel about the animals, that just the idea or the perception that someone would mistreat or not do what they believe to be due care to that animal. To them, it's something that would cause someone who's maybe just here on vacation to be like, that's a problem. I need to call animal control. It's something that would cause a potential juror to say, I don't even want to see any pictures. I don't want to hear anything about it. You know, it could cause another potential juror to say, I'm triggered just by the idea of something like that. And so, albeit your position, and I can only assume your position through how your attorney questioned, is that because there was no visible injuries and the dogs appeared to be in good health, that there was no mistreatment. But I think anyone would agree that if true, dogs should not be left outside in 23-degree weather in a wired kennel all day. And it would be concerning, I think, to anyone, to any neighbor. And if animal control has to keep coming to you, that's got to be something that strikes you as, I need to do something to keep them from coming to me. Why would you want animal control to keep coming by your house to talk to you about how you're caring for your animals? They're offering resource. They're offering support. And they're not here to be an enemy to you. They're here to be a resource to you. So if it means you go and you get some additional pay, if it means you go and you get an additional kennel or an additional tether or whatever it is that you need to avail yourself of those things, because at this time, I'm not going to withdraw the animals from your care because I don't think we have a reason to do that. But if there was a situation in the future, it could warrant that. And I don't think that's what you want. I think that you are someone who cares for your animals. And maybe what you perceived as care is not the normal standard. So I think the goal of Ingham County Animal Control and even this court is to make sure that you are doing more to raise the standard of care for those animals. And so with that being said, I'm not going to put on a term of probation. This is an incident, again, allegedly having occurred in March of 2025. I don't have any record or information that animal control has been back to this unit since then or to visit her about her animals. So I would imagine that the issue's been addressed. So you can correct me if there's something pending that I don't know about.
No.
Okay. Fines and costs is warranted. You're fine in this matter, $75 crime victim rights plus $50 state minimum cost. I'll waive discretionary fines and costs at this time. When will you make payment?
Friday.
I know that you'll pay by Friday. If you need an extension, you have to come to the court to request that, okay? Or contact the court, that is. Any additional matters for the record?
Enough of this, Your Honor.
Thank you. You're all set. Thank you.